So I call this meeting to order. Welcome to meeting number 113 of the House of Commons Standing Committee on Public Safety and National Security. Pursuant to the order of reference referred to the committee on Wednesday, May 29th, 2024, and the motion adopted by the committee on Monday, May 27, 2024, the committee resumes its study of Bill C-70, an act respecting countering foreign interference. Before we begin, I would like to ask all members and other in-person participants to consult the cards on the table for guidelines to prevent audio feedback incidents. Please take note of the following preventative measures in place to protect the health and safety of all participants, particularly the interpreters. Only use a black approved earpiece. The former gray earpieces must no longer be used. Keep your earpiece away from all microphones at all times. When you're not using your earpiece, place it face down on a sticker placed on a table for this purpose. Today's meeting is taking place in a hybrid format. I would like to make a few comments for the benefit of members and witnesses. Please wait until I recognize you by name before speaking. A reminder that all comments should be addressed through the chair. Specific comments on C-70. I would like to remind members that amendments to Bill C-70 must be submitted to the clerk of the committee by 4 p.m. Eastern Standard Time tomorrow, Friday, June 7th, 2024. It is important for members to note that pursuant to the order adopted by the House on May 30th, the 4 p.m. deadline to submit amendments is firm. This means that any amendments submitted to the clerk after the deadline and any amendments moved from the floor during the clause-by-clause consideration of the bill will not be considered by the committee. I would like now to welcome our first witnesses today. We have with us the Honorable Dominic LeBlanc, PC MP, Minister of Public Safety, Democratic Institutions and Intergovernmental Affairs. We have the Honorable Arif Virani, PC MP, Minister of Justice.
J'aimerais m'assurer au bénéfice des...
Yes, point of order. For the interpreters, I would like to make sure that all the audio tests have been carried out appropriately.
Thank you. Carrying on with our witnesses, we have officials as well. We have with the Department of Justice, we have Shailene Curtis McAuliffe, Deputy Minister and Deputy Attorney General of Canada. We have Heather Watts, Deputy Assistant Deputy Minister. With the Department of Public Safety and Emergency Preparedness, we have Sean Tupper, Deputy Minister, Richard Bilodeau, Director General. With the Royal Canadian Mounted Police, we have Mark Flynn, Deputy Commissioner, Federal Policing. And from the Canadian Security Intelligence Service, we have Sarah Esserbrooks, Director General, Policy and Foreign Relations, and David Vignon, Director. Thank you all for being here today and on such short notice as we have been doing all of this study. I now invite Minister LeBlanc to make an opening statement of up to 5 minutes. Please go ahead, sir.
Mr. Chair, colleagues, thank you. Good morning. Thank you for inviting me to be with you this morning on Bill C-70. It's a vital part of, I think, our government and Parliament's efforts to counter foreign interference. Thank you, Mr. Chair, for introducing the senior colleagues from our department, from the RCMP, and from the Security Intelligence Service who've joined me this morning. Mr. Chair, I think we can all agree that the government, and I think by conclusion Parliament as well, has no greater obligation than the protection of the Canadian people and our democracy. Tout comme nous, les Canadiens sont...
Like us, Canadians are aware of and rightly concerned about the pervasiveness and increasing complexity of foreign interference. They also know that foreign interference poses a real and serious threat to our country, our democratic processes, and our institutions. State actors seek to exploit Canada's vulnerabilities by targeting governments at all levels, our open academic systems, private enterprises, and even communities and individuals. And we must close those vulnerabilities in the face of ever-increasing and ever more complex threats, as many have pointed out.
Chair includes engaging with those directly affected on potential solutions, and that's why the Government of Canada engages with private companies, researchers, and the health sector, for example, to inform them of the threats and to help them better understand how they can protect their work, provides mechanisms for public reporting through various websites and national security threat phone lines, engages with communities at risk in Canada to help them better protect themselves against foreign threats, helps critical infrastructure operators defend critical cyber security systems that Canadians properly rely on, coordinates and shares information with our Five Eyes and other allies, such as obviously G7 or NATO partners, on foreign interference and other threats, and enhances collective resilience to disinformation by helping Canadians and individuals in Canada to become better informed about disinformation tactics and actors, and by enhancing transparency. Based on what we heard through consultations, a diverse and robust consultation process, we introduced Bill C-70, an act respecting countering foreign interference, earlier last month. In order to bolster our ability to detect and disrupt foreign interference threats, Bill C-70 proposes important and necessary amendments to modernize the Canadian Security Intelligence Service Act, the Security of Information Act, the Criminal Code, and the Canada Evidence Act. Moreover, Bill C-70 introduces the Foreign Influence Transparency and Accountability Act, designed to increase transparency by creating a Foreign Influence Transparency Registry for individuals and entities acting on behalf of foreign principals seeking to influence activities within our political and governmental processes. All individuals or entities who enter into an agreement with a foreign principal and who undertake activities to influence a government or political process in Canada would be required to publicly register these activities. Pour être clair, le registre crée une...
To be clear, the registry creates a positive registration obligation for individuals or entities who are in a foreign influence arrangement with a foreign principal. Individuals and entities would be required to show more transparency about their connections to foreign states and support Canada's national security objectives.
We recognize that the Foreign Influence Transparency and Accountability Act is by no means a single solution to foreign interference. That's why Bill C-70 also introduces measures and tools to help our law enforcement and intelligence agencies detect, deter, and decrease and disrupt threats of foreign interference at their early stages, while, of course, being mindful of the rights and privacy of Canadians. The Foreign Influence Transparency and Accountability Act would build on the government's ongoing and long-standing efforts to protect Canada against the threats of foreign interference. Mr. Chair, I can assure the committee that the government will continue to work with all our partners, including other jurisdictions in Canada, affected communities, academia, and civil society, to address foreign interference together. Mr. Chair, I also want to thank you and your colleagues on this committee for the work that you've been doing so exhaustively over recent days with respect to this legislation. We look forward to your deliberations with respect to amendments that might improve and strengthen this legislation. But I want to acknowledge what I think is an important, nonpartisan, collective effort from all parties in the House of Commons to work together on something important to Canadians, and I thank all of you for your efforts in this regard.
Thank you, Minister. I now invite Minister Virani to make an opening statement of up to 5 minutes, please.
Thank you very much, Chair. I'm very pleased to be here today to speak to you about the threat of foreign interference in Canada and how this bill, Bill C-70, aims to help detect, disrupt, and protect against the threats to our country and its institutions by foreign actors. Bill C-70 modernizes Canada's laws to better protect our democracy and protect people in Canada against new and evolving threats. We are particularly concerned about members of diaspora communities who are disproportionately targeted by those who engage in foreign interference. The reforms to our criminal laws proposed in the bill are strong, measured, and direct. Looking first at the Security of Information Act. This bill amends the existing offence of using intimidation, threats, or violence against Canadians and people living in Canada on behalf of foreign states. It simplifies prosecutions by removing the requirement to prove that the prohibited act actually resulted in harm to Canadian interests or helped the foreign state. All that would be required is that the threat or violence was done on behalf of or in association with a foreign state. The bill would also ensure that these protections extend to people working outside the country or traveling to visit loved ones. It would also ensure that the law addresses threats by foreign states against family members of Canadians. This captures instances where family members are being threatened to exert pressure on someone to do or not to do something, like protesting a foreign government. This is a significant step in addressing transnational repression and some of the fears we heard from community groups and stakeholders during the consultations which we have already undertaken. The bill also creates a new offence of committing an indictable offence for a foreign entity, as well as a new general foreign interference offence when a person knowingly engages in surreptitious or deceptive conduct for a foreign entity. We are also, Mr. Chair, strengthening protections for our democratic institutions. The new offence of political interference for a foreign entity criminalizes interfering with a democratic process and would apply at all times to all levels of government. That is a significant change, and importantly to the nomination process of political parties. En ce qui concerne le code criminel,
With regard to the criminal code, the bill proposes to modernize the current offence of sabotage, which has not been revised since 1951. We are also proposing to add 2 new offences to protect critical infrastructure and to criminalize the creation and distribution of devices intended for use in sabotage.
clarify that the offence applies to the public and private infrastructure that is essential to the health, safety, security, and economic well-being of people in Canada. For example, private and public infrastructure systems that enable transportation or communications or support the delivery of health and food services. Pendant les consultations publiques,
During public consultations, stakeholders from Canadian associations and industry clearly indicated the need to protect critical infrastructure. The proposed amendments would expressly recognize the Charter-protected right to freedom of expression and the right to freedom of peaceful assembly, and confirm that persons acting under these rights without intent to commit an act of sabotage do not fall within the scope of the offence. I will now turn to Part 3, which amends the Canada Evidence Act and the Criminal Code.
of the bill creates a new standardized mechanism with robust procedural protections to ensure the protection of national security information in the judicial review of government decisions. Through these important legislative proposals, our government is taking concrete action to protect all people in Canada, our institutions, and our democracy from foreign interference. These changes have been built with the input of Canadians, including members of many diaspora communities. They are balanced, they are fair, they are necessary. At this point, along with Minister LeBlanc, I would be pleased to answer your questions. Merci. Thank you very much.
Thank you, Minister. We'll start our questions with Mr. Caputo. Mr. Caputo, go ahead, please. 6 minutes.
Thank you, and I appreciate all of the witnesses being here. Through you, Chair, I direct the following questions to Minister LeBlanc. The NSCOP report that was recently released reveals that parliamentarians, including members of our House and the House of Commons, knowingly and deliberately assisted a hostile foreign state to the detriment of the people of Canada. This places a cloud of suspicion over every single member of the House, elected members. Do you know the names of these people?
Mr. Chair, through you to Mr. Caputo, thank you for the question. I am updated regularly, and I think in a complete way, by our intelligence agencies, by the RCMP, by the Department of Public Safety. So I am very comfortable that I have the information that I need to do the work that I have to do, but you'll understand that discussing the details, particularly of the most sensitive information, is not something that we want to do publicly.
Well, I'm not asking you to discuss sensitive information. I'm asking whether you know the names. Do you know the names, yes or no?
I know a number of names that were surfaced in various intelligence products that I have seen, but I was not in the room when the Committee of Parliamentarians did their work. I don't have the exact details of which documents they saw and didn't see, but I'm very comfortable that I have access to all of the most important intelligence information, which would include, in some cases, names.
Okay, so people who are alleged, and in some cases, according to our intelligence communities, to have committed some of the most serious offenses known to Canadian law, are you prepared to release those names, yes or no?
No, Mr. Chair.
You will not release the names of members, elected members, operating in the House of Commons. Do you think Canadians have a right to know, yes or no?
Mr. Chair, I think it's important for Canadians to understand that these names are contained in intelligence reports. In some cases, it's uncorroborated or unverified intelligence information. I think we would need to be very careful to understand that, as the director himself has said, intelligence is often a series of pieces of a puzzle, one particular. The idea that there's a perfect list of names that is entirely reliable that should be released to the public is simply irresponsible.
Minister, the NSECOP report doesn't equivocate like you just did. The NSECOP report is clear, incredibly clear on names. Do you think Canadians should have the right to know?
Not actually clear on names,
I'm not done my
Mr.
question, Minister. Do you think Canadians have the right to know when they go to cast an X next to the name of somebody in the next 15 months, the very thing that we're dealing with here in Bill C-70, do you think they have the right to know whether their member is under the influence of a hostile foreign state? Yes or no?
Mr. Chair, I think Canadians know, and I'm confident that they have every reason to be reassured that our intelligence agencies and the RCMP take their responsibilities extraordinarily seriously, have the resources necessary to investigate, and should the RCMP, for example, in their wisdom, decide that charges should be laid in consultation with the appropriate prosecutors, that's our system in a rule of law democracy. It's not simply releasing a series of names or doing, as Mr. Caputo says he's concerned about, casting aspersions himself on everybody by pretending that there's some perfect list of names that the government's not releasing. No other Western democracy knows this, and Mr. Caputo knows that certainly in the government of Mr. Harper, even that kind of conversation wouldn't have been conceivable. So I think there's a certain disingenuous element, Mr. Chair, in Mr. Caputo's theatrics this morning.
Disingenuous element. Under Mr. Harper's government, we did not get a report that said foreign state actors had infiltrated. Under Mr. Harper's government, we did not have reports saying that foreign state actors had dealt with this. Now, under current legislation, you can disclose top secret information when in the public interest. What would be more in the public interest than a person who could be elected and they are under the thumb of a hostile state actor? You can do that. So when you talk about disingenuous, you can do this. Why won't you before the next election?
Mr. Chair, speaking of disingenuous, in Mr. Harper's government, the National Security Committee of Parliamentarians didn't exist because Mr. Harper's government didn't believe that parliamentarians should have access to this information or be able to review the work of our intelligence agencies. Mr. Harper's government in 2013, CSIS publicly identified an increasing risk of foreign interference in our democratic institutions, and the Harper government did absolutely nothing. So again, Mr. Chair, I think it's important to have a context to these comments.
So you are okay with us going into an election, people putting an X beside a name where they have a cloud of suspicion, every single one of us. Let's face it, Minister, I think if there were six Conservatives on that list and no other Liberals, we would have had the names. Let's be honest here.
Thank you, Mr. Caputo. The Minister
pardon
may
me,
answer.
I think I have another minute here.
No, you don't.
No? Okay, thank you. I'm sorry.
The Minister may answer if you wish.
Mr. Chair, again, Mr. Caputo makes something up. If there were 6 Conservatives and no other political parties, of course we would release the list. Mr. Chair, I'm not going to violate the Security of Information Act and risk prosecution for a political stunt, and I think Mr. Caputo knows better.
We go now to Mr. Gahir. 6 minutes, please.
Great. Thank you, Chair, and thank you to all the witnesses for appearing before the committee. Minister, I wanted to focus on foreign interference and its impact on diaspora communities, something that Mr. Virani actually touched on in his opening testimony. I know you've spoken about in the past as well.
Point of order, Chair.
Mr. Dennis on point of order.
Thank you, Chair. During Mr. Caputo's round at the end, Ms. O'Connell was literally shouting at him across the floor, and now she's saying, "Boo-hoo, get over it."
Thank you.
Respectfully,
Thank you.
Chair,
Thank you.
I think you should call this member to order. It is a point of order.
Thank you.
You're shouting.
Mr. Dennis.
Shouting
Mr.
at another
Dennis.
member. No, sorry, I've got a point of order.
Speak to the chair, please.
Great.
I hear your point of order. I
Thank
would
you.
encourage all members to not talk across the table,
Yeah.
to talk through the chair when they recognize. It would be helpful to us all.
I hope you'll
Mr.
call Ms. O'Connell to order because she wasn't cross-talking. She was shouting in order to disrupt Mr. Caputo's round of questions.
Mr. Gahir, go ahead, please.
Great. Thank you, Chair. So I wanted to focus on foreign interference and its impact on diaspora communities. We've had different groups come and raise that concern as well. One of the groups that came was the World SECU Organization. They largely were in favor of this bill. They said more needs to be done to counter foreign interference. In that respect, Bill C-70 is a step in the right direction. They did want to highlight, however, that CSIS would have the ability to disclose information to any person or entity should CSIS deem that relevant. This would be a great step. They are concerned that whether foreign consular officials in Canada would count under entity and what kind of information could be disclosed to them, and whether diaspora communities could be put at risk because of that disclosure.
Mr. Chair, through you, Mr. Gahir, thank you for the question. Thank you for highlighting what I think all of us would properly be concerned about is the impact on diaspora communities in Canada. You're absolutely right. They are often victims and targets of this foreign interference. We've seen publicly reported cases that should worry all of us. So that is, I think, one of the reasons why it would be terrific if Parliament was able to strengthen in the appropriate way with the right safeguards the ability of our agencies to protect these communities, to protect Canadians. And you and I had a chance, Mr. Gahir, to talk about this specific element in terms of what information could properly be shared with different foreign governments or consular agents. I know that there are agreements that govern and properly so these kind of sharing arrangements. I think we can agree that the kind of information, and I'm speaking for my RCMP and CSIS colleagues, but I hope they won't disagree, the kind of information we might share, for example, with Five Eyes partners is different than we might share with a particular country that's interfering in an illegal and inappropriate way in Canadian affairs. But if you'd allow me, Mr. Chair, the Director of CSIS, Monsieur Vigneault, will be able to give, I hope, the precise answer to Mr. Gahir's very proper question.
Thank you, Mr. Chair. Thank you, Minister. I think the member points to something that is extremely important in the debate on foreign interference. There was a lot of focus on electoral interference, but minority communities have been targeted, continue to be targeted by foreign states, and that's why it's so important that we have the proper tools. In terms of information sharing, Mr. Chair, I can assure the member that there are very specific and reviewable guidelines under the Avoiding Mistreatment by Foreign State Act that govern the way we share information, and it is being reviewed annually by the National Security and Intelligence Review Agency, and we take this extremely seriously to make sure that we do not share information that would potentially harm Canadians.
Great, thank you. So what I'm hearing is there are the proper checks and balances before that information is obviously disclosed. The other point that was raised is there is a framework for cooperation on countering terrorism and violent extremism between Canada and India. That is still active. I think it was 2018 when that agreement was signed. When that agreement was signed, there was members of different diaspora communities, the Sikh community, for example, that had certain hesitations about that agreement. And so, those fears were heightened when news came out of Hardeep Singh Nijjar's killing in BC when the Prime Minister stood up in Parliament, and we all witnessed it. So the community is asking, and WSO is asking, what information is that agreement still active, and what information is being shared under that agreement, and is information being shared, or could it be shared, that puts individuals in danger, whether they're here in Canada or their families are overseas in India?
Mr. Chair, again, a very good question. I think it would be important to reassure the community that the appropriate protocols are in place and that their interests and their security is obviously paramount in any decisions that our security agencies might undertake. I don't, perhaps the director of CSIS or the deputy commissioner of the RCMP, because there would be, I assume, a criminal, in the case of a criminal investigation, for example, Mr. Najjar versus a terrorism investigation. But, Mr. Chair, if, with your indulgence, I think the director of CSIS and the deputy commissioner of the RCMP could provide exactly the information our colleague wants.
Mr. Chair, I'm happy to take that question. So within the RCMP, and I know my colleagues at CSIS and other departments have similar processes, we have a process that ensures there is a proper risk assessment, and independent individuals who are not part of those investigations are brought in to analyze the information, the request for information, and our responses to those, to ensure that any information that we are going to share with any foreign entity is properly assessed to ensure that it will not cause jeopardy to any individual, and that's any individual, whether Canadian or otherwise. I recognize the concern that is raised, and it's something that we as law enforcement and security and intelligence officials have to deal with every day. It is a global community. There is many problems that are global in nature, and the reality is we do have to communicate with people and with countries that do not have the same values and ethics as Canadians and as in Canada as a whole. However, I can assure you that we take all of those engagements very seriously, and we exercise extreme caution in all of those engagements.
Thank you, Mr. Gahir. Yeah. We go now to, on y va maintenant, Monsieur Villemur.
We will now turn to Mr. Villemur. You have the floor, sir, for 6 minutes. Thank you very much, Chair, and thank you all for being here. Many of you, indeed, highly impressive. My questions are for Mr. Virani, but I'll begin with Mr. LeBlanc, if you don't mind. Mr. LeBlanc, I've been following this file, foreign interference, very closely for quite a while, and I understand your answers, to the effect that you cannot provide a list of names. The nature of the information, secret, top secret, and highest secret, must be respected. So, understood. We're not requiring that you make this information public. We understand the situation. However, we're wondering what may occur. Can you give us a bit of an overview? The impression we have is that in the past, people were slow to react. The special reporter, et cetera, there were documents that weren't necessarily shared. With the public inquiry, for example, given the importance of this issue that you have underscored and your interest in sharing information that you can, what can we expect? So through you, Chair, to Mr. Villemur. Excuse me? Excuse me, we're not receiving the interpretation on Zoom.
We need someone speaking in French.
Testing, the English channel. Testing.
We're going to suspend for a minute and get this straightened out. Oh. Looks like we're good to go. Désolé, monsieur, allez-y, s'il vous plaît.
So please resume, sir. Thank you, Chair. Very well. Mr. LeBlanc, then I turn back to you. So what's your answer to my question? Mr. Villemur, thank you for your question. Thank you as well for your work and your party's work in support of the bill and to improve the bill as well. I fully understand the meaning of your question, how sincere it is, and I applaud your wish to ensure that we do everything as well as we can. You're right, and you have touched on the reasons for which it's not possible to give some sort of magical list of names, but it's important to reassure Canadians that the highest democratic institution of our country, the House of Commons, that we have the privilege to sit in, be, as much as we can possibly ensure, safeguarded from foreign interference, and to ensure that anyone who gets involved in foreign interference is held accountable. Without being overly dramatic, I believe that because I've had the privilege in my position as Minister of Public Safety I've been able to work with our security agencies, our intelligence agencies, and I'm fully confident that anyone trying to do something that's illegal, that harms Canada, will be held accountable. Of course, in the election process, we have the Canada Elections Act. We have a number of mechanisms. You referred to the Hague Commission. Correctly so. I worked with great pleasure with your parliamentary leader, Mr. Terrien, last summer to create the Hague Public Inquiry, and I'm very interested in their work. I look forward to receiving their reports. We had the NCCOP work of this week and the review agency as well, the NSIRA, and we're looking forward to any amendments you have to the current bill before Parliament. Of course, the aim and the deep wish is to reassure Canadians, our institutions, and our partners and the security agencies that we have all the means available to counter this threat. We look forward to the Hague Public Inquiry results, and we may have a little time left to improve and to bring down new bills. So we're on the mark, ready to go, do everything we can to help Canadians and to reassure them as well. We do not want to leave Canadians with the impression that there are any members of our House who are not accountable under law. Everything will be done as appropriate. Yes, but you will understand that in the past, it often took a long time for solutions to be seen on the horizon. You know, confidence, transparency, and exemplary action. That's what we're hoping for. Now, back to the bill. Oddly, this bill doesn't seem to actually define foreign interference. There are a few definitions we can kind of make out, given how it's used in the text, but there's no actual definition, and something that's not defined doesn't really exist, right? Well, you're right on that. In my discussions with my colleagues at the department and with our partners in the security agencies, that question came up. Of course, there will be lawsuits, criminal lawsuits over the years, and basically the courts, as they must, will define the elements of the criminal offense. That's the way legislation and law works in Canada. There are also new tactics continuously being developed inasmuch as the threat evolves month by month and year by year, given the new technologies. The definition is shifting, let's say. So defining it specifically might have restricted the application of the legislation. But I have full confidence in our partners. Thank you very much. Mr. Pirani, I'm not a criminal law expert, but yesterday we had a criminal specialist tell us about very specific sections of this bill which she felt were imprecise, too unclear to be able to be dealt with so quickly. So I must say that I, therefore, am uncomfortable changing the criminal code so quickly. I can't argue on each of the sections and amendments to the criminal code, but the concern was that there were some elements that weren't precise, perhaps some unexpected results should we adopt these changes to the criminal code. So what could you do to help us to do our work appropriately? And I think that working really quickly is not the best way forward. Thank you for the question, Mr. Villemure. I can add a couple of things here. First, with the changes to the legislation of 2016, I believe, it's necessary to table in the House statements about any ways in which a bill affects the Charter of Rights and Freedoms. So that's already done. And you've brought up a context in which any freedom might be at issue, but yes, that must be discussed openly in the House and specified. So here we have written a bill influenced by our in-depth consultations, and this is a delicate matter, of course, but it's also a matter of the highest importance for Canada. And it's a priority to modernize our legislation, in particular with regard to sabotage, the act of sabotage. Thank you, sir. Don't you think we're moving too quickly, though, that as parliamentarians we're not able to weigh this in depth? Thank you. Thank you, sir. I'm so sorry. Your time is up.
We will start our second round. Oh, sorry. I'm way ahead of myself. I apologize. Mr. McGregor, if you would please go ahead with 6 minutes.
It's a consequence of these new long table setups. I get lost in the mix here. Thank you, Mr. Chair, and thank you to our witnesses for joining us and helping guide this committee through this really important study. Minister Varani, I'd like to start with you. I have some questions about the amendments to the Security of Information Act, otherwise known as SOIA. Now, in the existing SOIA under Section 24, it says that no prosecution shall be commenced for an offence against this Act without the consent of the Attorney General, meaning yourself. I guess I just have a question because there are some very consequential amendments to SOIA in this bill. Particularly the new section 20.4 that's going to be added with respect to political interference for a foreign entity. I mean, I'm just looking ahead. The position of Attorney General is filled by an elected member of Parliament, and I'm just wondering, would it not be safe to maybe remove the requirement for the consent of the Attorney General, given that you're dealing with offenses here that are of a political nature? Would it not be better to perhaps lead that to a senior civil servant? Do you have any thoughts on that?
I do. Thank you, Mr. McGregor. It's an important point. I'd say a couple of things. One is that AG consent is in various places throughout the criminal code. We can talk about the context of a prosecution for some of the hate propaganda offenses, for example. It's in the code for specific reasons, but primarily as a safeguard. When we express an understanding, we want the code to reflect that understanding, that the interests that are in play are very, very significant. And when you're talking about potential restraints of charter rights in the context of something that might have been orchestrated by a foreign nation, I think you're talking about very serious crimes as opposed to a simple break and enter or uttering threats. The last piece I would also say is that I appreciate your point. I would reflect on the fact that we had a pretty extensive analysis of the division of the role between AG and the Minister of Justice, and that was done by a former Attorney General herself, Anne McClellan. She talked about how the system that we have can continue to work. But I think actually having somebody with a person such as in my role right now reflecting on it is important insofar as what we're also dealing with when we're dealing with foreign interference is potentially very sensitive information of the type described by Minister LeBlanc that deals with sensitive state relation matters, both with the state that's at issue, but also with the other states that may have been cooperating with us to provide us the intelligence. I think given that aspect, I think it's very important for somebody who has a political lens to actually provide input as to whether the prosecution should or should not proceed.
Thank you for that. I also have another question dealing with this same clause in the bill, and Clause 53 is a very big clause. But now the amendment to Section 20 of the SOIA, where it's talking about intimidation, threats, or violence, and we have the word intimidation inserted in there. I've heard concerns from some groups that intimidation is not defined in the SOIA. That could be hugely problematic and because it could be open to interpretation. For example, if you have two groups who may have foreign association, but are different ends of the political spectrum. Is there not a danger that a government of differing political natures may see those two groups in different lights? Like, how do you define intimidation? Is that not problematic, not narrowing it down further?
Thank you for the question. Just in terms of reflecting on the previous question, I just want to also underscore that the AG consent can always be delegated down, as it's done in some provinces, to what's called the Director of Public Prosecutions. In terms of your second question, I would say we're guided by intimidation in terms of intimidation case law, as it's been interpreted by courts, because it's a term that's used in the criminal code and also entrenched in the criminal code. But you raise a really important point, Mr. McGregor, which is just this idea of ensuring that lawful dissent and protest, including a labor work stoppage at an important piece of potential infrastructure, is protected and remains protected, and that's why that language has been deliberately inserted into the bill, because we don't want this to turn into sort of a situation where ideology motivates whether people are being coming under the penumbra of potential prosecution initiatives. It is always when there is an element of foreign interference and something that is not proper lawful dissent and protest, but actually transfers into something that is more reprehensible, that is actually trying to influence Canada and subvert Canadian interests.
I think I have room just to get one more question in. So when I'm reading through Bill C-70, there's obviously a thematic nature to most of the amendments. We have important amendments to the CSIS Act, to the SOIA, the Canada Evidence Act, and of course enacting a new act to deal with a foreign registry. What seems to stick out, though, are the amendments to the criminal code, particularly as it relates to sabotage. I'm just wondering if you could provide some rationale to this committee as to why it seems so important to update amendments or update the definition of what sabotage is in the criminal code in a bill that's primarily dealing with foreign interference.
I think it's, in frankness, Mr. McGregor, it's reflected on what we heard in the consultations and where we are as a nation. I mean, it troubles me that the sabotage provision haven't been amended in 75 years, maybe 85 years, since 1951. That is a tremendously long time to not update an important piece of an important sort of definitional provision in our laws. And I think it's also reflective of the fact of what we're seeing. And that's both the work that you guys are doing at this committee, what we're seeing from SECU, what we're seeing from Madam Justice Ogue's inquiry. What we're learning about is that foreign interference is very present, and it affects essential infrastructure. It affects various levels of influence in terms of various components of Canadian society. And I think particularly modernizing the sabotage offense is what we need to do to make sure that we are being responsive to the threats that we're facing and ensuring that Canadians have confidence in the approach that we're taking to what is a very pernicious issue. Thank you.
Thank you, Mr. McGregor. And once again, I apologize for kind of redacting you earlier. So we're going to start our second round. We have been terminating our second round sort of after Mr. McGregor. We have requested if the ministers can stay another few minutes beyond that, we will give the Conservatives and the Liberals an additional 2.5-minute slot. So, Mr. Cooper, if you please, 5 minutes.
Thank you, Mr. Chair. Minister LeBlanc, you said moments ago that the House of Commons must be safeguarded from foreign interference. I completely agree with you in that regard, and yet the SECU report released this week unequivocally states that elected officials, including certain members of Parliament, are working wittingly, and I emphasize the word wittingly, with hostile foreign states, including frequently communicating with foreign missions, providing foreign diplomatic officials with privileged information, and sending secrets to intelligence officers of foreign states. I would submit that as long as the Prime Minister continues to cover up the names of these compromised MPs, a dark cloud will continue to hang over this place. So I put it to you again, who are the names of these compromised MPs? Who are they? What are the names? What are their names?
Mr. Chair, through you, I'll repeat the answer that I gave to Mr. Cooper's colleague. The release of that sensitive, highly secret intelligence information is governed by law. I think Mr. Cooper knows very well that
Minister, with respect.
Point of
Mr.
order.
Chair, I was trying to answer the question.
Ms. O'Connell on a point of order.
Mr. Chair, perhaps you need to provide a reminder to committee members that questioners must give equal amount of time for the witnesses to answer. And stop with your
the same point of
pretending
order.
of reading the book.
Ms.
I
O'Connell?
know your favorite
Ms.
thing to do
O'Connell?
on a Friday night is pretend to be chair. But, Mr. Chair, please give a reminder of the decorum around this committee in dealing with witnesses.
Thank you. Well, let's
On the
avoid-
same point of order,
Miss-
Chair.
Mr. Janice, on the same point of order.
Yeah, there's no requirement whatsoever for equal time. It's the member's time. That's well established. And whether you read the book on a Friday night or a Saturday night, it will say the
Hey,
same
that's-
thing on that.
We're getting a debate here. Let us continue. Mr. Cooper, I would appreciate if you give the witnesses a chance to answer the questions you ask. Go ahead, sir.
Yes, well, with respect, Minister, I'm not asking you to release the intelligence. I'm not asking you to release sources and methods. I'm simply asking you to release the names. There is no legal impediment preventing you from doing that, preventing the Prime Minister from doing that. So why is the Prime Minister continuing to cover up the names to shield these MPs who are compromised by hostile foreign states?
Mr. Chair, far from it. The Prime Minister and our government have strengthened Canada's ability to detect and counter foreign interference. We're discussing today landmark legislation that the committee is working on that would strengthen the ability of our intelligence agencies and the Royal Canadian Mounted Police to do the work of holding those that violate Canadian law to account. So, Mr. Chair, again, I have every confidence that...
Minister, we already know that one former Liberal MP, the member for Don Valley North, received help from Beijing to secure the Liberal Party nomination, and we know that the Prime Minister was briefed about that during the 2019 election before that member was elected while he was a Liberal candidate, and the Prime Minister did nothing about it and covered it up for nearly 4 years until he got caught when it was reported in the Globe and Mail. The Prime Minister has a disturbing track record of putting the partisan interests of the Liberal Party ahead of transparency and protecting our democracy and national security. Isn't the real reason the Prime Minister won't release the names because some or all of these compromised MPs happen to be Liberals?
Mr. Chair, through you, I congratulate Mr. Cooper on the clip you probably just tried to get for social media. The simple answer is no.
How many compromised MPs are there? Since you won't release the names, how many are there? Just a number.
Again, Mr. Chair, Mr. Cooper knows full well that the information that underlies the conclusions of our intelligence agencies or the RCMP is highly protected, sensitive information that often comes with caveats from foreign partners.
Minister, I asked you simply for a number. How many compromised MPs are there?
Mr. Chair, Mr. Cooper knows very well, and I get the theatrics. He's very good at that. I think he should be perhaps given a gold star for theatrics. But he also knows...
Minister, this is about as serious as it gets, that we have members of Parliament working for hostile foreign states. You won't release the names. At the very least, Canadians deserve to know how many MPs are compromised. How many?
So, again, Mr. Chair, I explained earlier this week, and perhaps if Mr. Cooper is interested, the director of CSIS or others could explain the challenge of taking...
Minister, perhaps we can narrow it down. Are any in Cabinet? Are any sitting around the Cabinet table?
Mr. Chair, Mr. Cooper can pretend to be a prosecutor if he wants. I was...
Pretending to be anything. I'm asking you a very straightforward question as to how many compromised MPs there are, and are any in Cabinet? Just an answer.
Thank you, Mr. Cooper. That's your time. The minister may answer if he wishes.
No, Mr. Cooper doesn't seem to be interested in the answer. He's more interested in interrupting, so we'll go to the next question.
Well, I didn't answer.
Thank you. We go now to Ms. O'Connell for 5 minutes, please.
Thank you, Chair. Thank you to the witnesses for being here. Minister LeBlanc, has the leader of the official opposition, Mr. Poilievre, received his security briefing, or security clearance, sorry?
Mr. Chair, through you to Ms. O'Connell, no, he has not, because we've offered, as I think colleagues know, on a number of occasions to process the appropriate clearance for the Leader of the Opposition, so he could perhaps see some of this exact information that his colleagues seem so interested in us releasing, but he has not made such a request.
And is the offer to provide him that opportunity for security clearance still available to him?
Of course it is, Ms. O'Connell, and we were very pleased, for example, the Leader of the New Democratic Party accepted our offer, and we think that's a collaborative, constructive way to make Parliament, to increase the confidence that Canadians would have in our democratic institutions.
So, Minister LeBlanc, Mr. Cooper just said this is an issue as serious as it gets, yet his leader refuses to receive a security clearance that would actually allow him to have the full information that, frankly, NSECOP members would have. It would allow him to be able to go to Canadians and his own caucus to say, listen, I've reviewed the information, I can't reveal the details, however, I feel confident that some information is uncorroborated. I feel confident that other information is further being pursued by law enforcement, but I feel confident in our democratic institutions. Instead, in, quote, the most serious issue as it gets, according to the Conservatives, they purposefully decide to be ignorant to the issue, instead throwing around fake sanctimonious accusations about numbers of compromised MPs, what that might mean. And, Minister, what this provides in the sanctimony of pure chosen ignorance by the Conservative Party is the fact that it will create mistrust and distrust in our democratic institutions with the ability to be informed. Their very own leader has the ability to be fully informed of what's going on in this serious matter. Instead, choose blind ignorance, which creates mistrust, distrust, and who benefits most from mistrust in our democratic institutions? Foreign states who hope to influence it. And Mr. Minister, it's also, accusations have also been thrown out about influence in the Leader of the Opposition's own leadership race. However, is it not completely inappropriate to start making accusations about some pieces of intelligence and not, and funny enough, it's actually my time and I can make comments, but funny enough, they leave that accusation out of their comments. Do you find it irresponsible for a leader of the official opposition who hopes to be prime minister one day to be so ignorant and blind to quote such a serious issue, as serious as it gets?
So, Mr. Chair, through you to Ms. O'Connell, thank you for the question. And you're absolutely right. If the Leader of the Opposition was serious in understanding the information underlying the NSECOP report, and Ms. O'Connell has served on this committee of parliamentarians herself, so would know this better than I do, but the committee produced two reports. It produced a top-secret report for the Prime Minister and for our intelligence agencies, and it produced a report that was released publicly earlier this week. And the report that was released publicly, of course, was subject to all of the appropriate legislative protections, and Mr. McGuinty has spoken about this publicly. But if the Leader of the Opposition was interested in seeing the highly sensitive information that the Committee of Parliamentarians saw that informed their top-secret version of the report, he would simply have to indicate that he is prepared to receive the appropriate security clearances, and then he would have access to that information. So I think in the way, for example, the Leader of the New Democratic Party can and will. So to us, that is a responsible, thoughtful way in the difficult world of intelligence information that comes with caveats and the need to protect sources and methods. That, to me, is a responsible, thoughtful way to do it. It's not the path the Conservatives have chosen. And I thought your speculation as to some of the reasons, Ms. O'Connell, were absolutely valid.
Thank you, Chair. Minister, the Conservatives would like to pretend that this is somehow a cover-up. However, the information that is protected and deemed secret or top secret status would be governed by law and legislation. Was that law and legislation in place during previous governments, or is this somehow new law, things like the Espionage Act?
So, Mr. Chair, again, a very good question. The protections of this information, and the director of CSIS and the RCMP have spoken about the reasons why it's important for us to be able to do this work and the law that governs that. It's no different from conversations I've had with Five Eyes colleagues and other allies of Canada. But in terms of the particular legislation that's existed for a number, perhaps the director can give you a quick sense, Ms. O'Connell, of the different pieces of legislation that govern the release of this information and how long they've existed. I know we're celebrating CSIS's 40th birthday this year. All of you, I'm sure the director will invite all of you to the party in a second. But perhaps David wants to add something.
Yes, thank you, Mr. Chair. The legislation is quite clear and has been in place for some time. The Security of Information Act is there to protect sources and methods, but also protect against disclosure of information that would be injurious also to the people. And I think we have seen, the impact of the leaks, and when classified information is released, there are challenges that, comes with it that, we try to make sure that in a democratic environment that we address the national security threats, but that we are also addressing, and we're doing it in a manner that is respectful of the law.
Thank you. And this actually is the protection of people, is not protection of some opposition leader or some parliamentarian. It's actually those who are serving our country, collecting this information, who could be put in danger by the release of sensitive information.
Ms.
Is that not accurate?
Sorry, I was distracted by other things. You're way over. We'll have to cut it there. On y va maintenant, Monsieur Villemur.
We now turn to Mr. Villemur. You have 2.5 minutes. Thank you so much, Chair. I'll do what I can in 2.5 minutes. Mr. Virani, Honourable Minister, you have carried out a number of consultations before this bill came down. How much time? For how long were we consulting? The most recent consultations lasted for a few months, and before that, before I arrived in Cabinet, I will ask the officials accompanying me to help me with that, to provide an answer.
The consultations on the justice parts of the bill ran from November to February, I believe. And prior to that, there were consultations done by our colleagues in public safety on the registry that I believe started in May of 2023, if memory serves.
So about 3 months.
For 2 months, yeah.
2 mois pour les...
And then another 2 months. All right. So 2 months for the public safety elements and 3 months for the other parts. That's why I find it difficult to look into this in 4 days only, because the implications are deep, serious, and this is working a little too fast. I'll get back to what you said earlier. It's true that party leaders can request security clearance at a level that would allow them to examine secret information. But that being the case, they're also held to keep this information secret. So the offer is much appreciated, but isn't very useful to us. Would there be any other way we could use to get the information besides that? Once again, I understand how sincere your question is and understand your concern. So possibly, Mr. Villemur, let's say that the leader of a party had access to a secret report from SECU, the version that cannot be made public, and use that information to make some responsible decisions in their capacity as leader of a party. That is one scenario, and you're quite right. The leader of a political party, just like all of us, like my colleagues in the intelligence agencies, is held to secrecy. So you're right on that. But it might be a good tool that they would have to help them make decisions, let's say, about nominations to his party, potential MPs. Yes, but nevertheless, the secret part would have to be respected. Yes, thank you.
Mr. McGregor, please, 2.5 minutes.
Thank you, Chair. Very quickly, Minister Virani, we've heard the term transnational repression come up from a few witness groups. Are you satisfied that the amendments to SOIA in this bill cover what groups are concerned with on transnational repression?
I am. I think we've listened to that concern, and I think we've addressed it in a flexible way as possible to capture as much transnational repression as we can.
It's been something I've been just wondering as a committee member. Minister LeBlanc, I want to turn to you. I think from the exchanges that we've had, there's an obvious difference between intelligence and evidence, and there's a real struggle that, you know, it can be a struggle using intelligence to get to evidence because of the secret nature of the sources. I understand all that. And I also understand that, that our leader, Mr. Singh, he took that briefing because, of course, foreign interference has directly impacted him personally. And we know it has affected his personal life, where he can go, his family, and so on. I think that's very much public knowledge. But I wanted to know, I wanted to get your thoughts just on Part 4 of this bill. When we're creating this public registry, there's a definition in the bill on arrangement, and it reads out, you know, being under the direction of or in association with. Now, this is going to be a public registry, but there's a very real difference between being under the direction of a foreign principal and in association with a foreign principal. So I'm just would like to hear from you, how do you see the difference between those two terms? And, you know, this is going to be a public registry. It could have some severe implications for the people who are put on it, even if they're just in an association with a foreign principal.
Mr. Chair, through you, Mr. McGregor, thank you for the question, and I think you're right to identify your leader's thoughtful approach to this issue, and I think Canadians, because it was part of the public record, were understandably upset in terms of him and his family potentially having been targeted in some of these contexts. So I certainly continue to share a concern around his ability to do his work as a parliamentarian. And you raised, Mr. McGregor, a good question. I know that Mr. Bilodeau, who's worked on the details of the registry in terms of the principles and why we all, I hope, are in favor of the registry are well known. I won't repeat them, but the specific distinction as to in association with or under the direction of, I do get thinking about a solicitor-client relationship, for example, how that might be different, but maybe Mr. Bilodeau can give you a precise answer to that question because it's a good one.
Thank you, Minister. And Chair, the answer is that the bill is intended to capture a broad variety of arrangements that doesn't require to be in writing, but there would still need to show, the Commissioner would still need to show that there is some sort of understanding between a foreign state and an entity in Canada to conduct the influence activities. And it was built this way to allow the Commissioner the flexibility to enforce the legislation. To the point about individuals being identified on the registry, by virtue of that arrangement, there are recourses within the legislation that an individual who felt that he or they should not be listed, there's an opportunity for judicial review of that decision, and so the safeguards are built into the legislation. And the last point I would make is that the Commissioner will have the ability to issue interpretation and guidance, and that could inform how they will see what they consider an arrangement.
Mr. Chair, if I could just add in 10 seconds, the registry is not sort of a stigmatizing entity where it's sort of implying criminal conduct or inappropriate conduct. It's a transparency document, so it's an important distinction.
Thank you, Mr. McGregor. So we're substantially over time, but since I messed up with Ms. O'Connell and gave her substantially more time, I'm going to give Mr. Motz 1 more minute for a question.
Thank you very much, Chair. Thank you, ministers. So, given the importance of C-70, we know that Parliament has been doing its job, and now we want the government to do theirs. So, will each of you ministers commit today to have C-70 in place and fully implemented before the next election? Yes or no?
That's certainly our objective, Mr. Chair. We recognize the urgency. That's why we appreciate, as I said in my opening comments, our House's work. We don't know what the Senate will do, but the elements that are within the government control, I can assure our colleagues in terms of the implementation of the legislation, we will ensure that they're in place.
Just quickly, how do you plan then to implement that? An order in council or some other thing? Because the officials have said it could take a year. We may not have a year. So would an order in council suffice to make sure it gets done before the next election?
again, I'm not an expert in terms of an order in council. Certain provisions of the appointment of the commissioner, all of these things will be proceeding expeditiously, consulting Parliament, of course. But maybe Mr. Varani, in terms of the order in council coming in. But Mr. Mott, it's a very good question. I think colleagues should be under no illusion that we very much, like I think you do, want to have this in place before the next potential election. That's why we're so encouraged by the work that's going on here. But Arif, did you want to add something?
Yeah, I would just say that Minister LeBlanc and I will work cooperatively to prioritize this legislation. It's very, very important, as has been underscored. I would just note, Mr. Motz, that the coming into force provisions are 60 days after royal assent. We can't control the Senate process, but we'll do everything in our power to ensure legislation of this nature is prioritized.
Thank you.
Thank you, Mr. Motz. And thank you, ministers, for all of your great testimony today. It's most helpful. So we are going to be losing a few of our officials, and we will be getting a few new ones. So we will suspend as we replace the panel. So I call this meeting back to order. So I would like to welcome the new officials who are joining their colleagues at the table. From the Privy Council office, we have Nathalie Durin, Deputy Clerk of the Privy Council and National Security and Intelligence Advisor to the Prime Minister. And with the Department of Justice, we have Mark Scrivens, Senior Counsel, and Karine Bolduc. I'll try this again. Karine Bolduc, Counsel. Thank you, and I apologize. So I understand officials will not be making opening statements, so we will now open the floor for questions. So we will go first to Mr. Caputo for 6 minutes.
Thank you, Chair, and thank you to the officials for being here. I generally will just pose a question when we have officials, and whoever feels most that they can answer it best, please feel free to chime in. Now, there was some discussion about a security briefing and whether somebody who has a clearance can receive a security briefing. For instance, the leader of the NDP has said he would like to get a briefing. Can anything be divulged from the information in that briefing if a person receives a briefing, as in, can somebody then question the government based on the information in that briefing?
Mr. Chair, this is, I think it's a really important question and that speaks to the fact that as a nation, I think we're going through an evolution in how we're addressing national security issues. So this is a bit uncharted territory. In my experience, we have never seen politicians, leaders having classified, having security clearances and be in a position to receive information. We have seen in the past that some of these briefings, people who have received classified briefings have spoken publicly about what they were told. That it creates an issue because the information may not be exactly how it was divulged, and it also, the ability to protect sources and methods and the people who are gathering this information might also be at risk. So I do believe that there is an evolution that is required. That said, there are absolutely limits to what the leader of the opposition will be able to say. The question is, are there an ability to reduce the threat of foreign interference by having the information and being able to take some decisions? And I think this is the discussion point and the evolution of our system that is required now.
So, Mr. Vigneault, if I could ask then, if I receive a briefing tomorrow, could I then ask questions in the House of Commons specific to perhaps the names of the people or what I saw? I'm seeing your colleague shake her head. In other words, there's a proverbial muzzle based on what is learned in that briefing. Is that not right?
Mr. Chair, I would probably use a different characterization. I would say that the law would prevent the member from speaking. The challenge that we have is that there's the law and there's also the privilege in the House of Commons. And this is something that, again, in terms of the evolution of how the system should work, is if someone gets information in a privileged way and then, use the privilege of the House to divulge information, I think, we are in a bit uncharted territory of how this would be done. And that's why, as a professional intelligence person, my advice would be that there's a need for a lot of discussion about this to create a new modus vivendi for Canadians.
I understand that, and perhaps when I say muzzle, I mean the law would muzzle. So I'll ask the question in a different way. If an opposition MP receives a top-secret classified security briefing and learns top-secret classified information, including the raw intelligence that Minister LeBlanc just referenced, then would the MP be able to act on that information, or would acting on that top-secret information potentially violate national security law?
Thank you. I'll take that question, Mr. Chair. Yes, of course, they can act on it. And this is why recently I have offered to all parties to have a clear representative, in particular the leader, in order to receive those information and, for example, to be able to act during a by-election, be able to act during a general election, managing their caucus, for example. Also equipping themselves in terms of how they how they behave, what kind of events they are attending to, what kind of relationship they are keeping or not. So there's a lot of things that they can do when they are being armed with this information without, disclosing publicly the information they receive.
But they can't discuss the information is my point. When I say act, I'm saying deal with this information publicly, as in ask the government the hard public questions on this, and ask the government specific questions as to what is in the briefing. You can't do that. I think that's my point.
Minister Virani explained, the legislation we have to prevent that. But behind those legislations, there are some fundamental principles. Collecting information through intelligence processes, this is not a contradictory process. C'est pas un processus contradictoire.
It's not a contradictory process.
The target of those collections are not in a position to defend themselves. And this is why, we talked about having the right balance between a very effective legislative framework when it comes to intelligence and national security, while also protecting human rights. And I do believe that disclosing names that have been collected through intelligence processes will be contrary to our privacy principles, but also contrary to our human rights principles.
Well, would it not be, the minister can disclose classified information when it is in the public interest. What could be more in the public interest than whether a person is putting an X on their ballot next to the name of somebody who has been compromised by a foreign state actor?
Maybe one thing that I can say, there's a lot of mechanisms to reduce the threat. For example, CSIS can do a threat reduction measure, a defense briefing. The leader can manage its caucus. We can do a démarche in front for the foreign actors. We can we can do what we call the PNG, persona non grata, for a consulate, for example. So a lot of things can be done
I understand
to reduce the threat.
Sorry, I'm not trying to interrupt. I just have a little bit of time. What I'm saying is what could be more in the public interest?
Mr. Caputo, that's it. Thank you. We go now to Mr. Biddle, please. Mr. Biddle?
According to Mr. Cooper, my time is running out. I think that was a veiled
6 minutes, please.
Oh, yes, I have 6 minutes. Not my time is running out, Mr. Cooper. That's adorable. Anyway, my questions will be to Department of Public Safety. We heard testimony from witnesses who raised concern that the provisions found in the bill won't apply to national political leadership races and conventions. Is that indeed the case? Or your interpretation of that?
So the Act defines or includes government and political processes. There is a list of what that includes. It is a non-exhaustive list. Our interpretation of the bill is that it captures leadership contests because it is a political process. Ultimately, though, it'll be up to the commissioner, but that is the intent of the bill.
One of my colleagues has been asking witnesses their thoughts on the use of the word association in triggering registration obligations. Some have raised concerns that the word association is too broad. Can you comment on why this was chosen and how you believe it will be interpreted?
Sure. Thank you very much for that question, Chair. The definition of arrangement was chosen to identify situations where an individual is, acting, yes, in association or at the direction, but it's meant to communicate that there must be some form of understanding between an entity that is conducting the influence and on behalf of the foreign power. So there has to be some sort of understanding agreement. It was purposely not narrowed because we wanted to make sure that no type of arrangement, if that understanding has occurred, escapes registration obligation, because this is about transparency. There is a limit, obviously, if somebody decides to, on their own, without talking to anybody, without an understanding, to say something, there's no registration obligation at that point, but it's meant to capture a broad set of circumstances.
Another topic that this committee has spent time thinking about is on the independence of the commissioner. We know from the bill the commissioner will be housed within Public Safety Canada. Why is that decision made, and what benefit does it provide?
Thank you, Chair, for that question. The model that is proposed in the bill is intended to situate the commissioner in a Department of Public Safety, but with the ability to act independently in their mandate. The reason that was put in the bill is to benefit from the existing infrastructure that exists within the public safety portfolio more broadly with CSIS, with the RCMP, to facilitate information sharing, because the commissioner will ultimately need to rely on not just complaints or their own investigative work, but intelligence that might be shared with them to inform their investigations. And by placing it within public safety, there is a increased facility in being able to do that, both from authorities to share information, but also just physical infrastructure to receive that information. But ultimately, the decisions the commissioner will make are their decision. Their reports are their reports.
So is there any way for the minister to direct those reports or what the commissioner is doing?
The bill indicates that the minister must cause the report to be tabled, but ultimately it is the report of the commissioner, and the minister would not have the ability to change that.
Are there any logistical challenges in making the commissioner an independent officer of Parliament?
I'm not a machinery of government expert, Chair. I would defer to people who are, but it would require a different approach and would definitely be more complex than setting it up within the Department of Public Safety, and could take more time.
So, and I agree with the opposition members who have raised this, who want to see this in place before the next election. If we make, or if we amend the legislation to make the commissioner an independent officer of Parliament, could that delay implementation of the bill after the election?
Thank you, Chair. It's a difficult question to answer just because, as I said, I'm not a machinery of government expert in setting up offices of Parliament. But just in terms of being able to speak to my area, just being able to set up the infrastructure, it would definitely would be easier within the Department of Public Safety.
Fair enough. If I can turn a little bit to CSIS, because I think I'm sympathetic to some of the arguments made, like transparency. Let's release the names. We need there to be openness and transparency. But we've seen in the past individuals' names leaked through the media and no context added. I'm thinking of the Aurora case going back, that's probably 20 years ago. What are the consequences of just sending names out into the ether without any context or behind it?
I think the example that the member is using is quite different than what we're talking about here, just to be precise. I think, but the issue here is releasing classified information without context, without the ability to protect the information. A lot of this information comes very significant, very sensitive sources. And the ability to protect Canada is to be able to collect that intelligence. And so releasing information can damage the reputation of individuals who have no ability to defend themselves, can also damage the ability of the agencies, including CSIS, to do their work in the future. And that would therefore damage Canada's national security. So I think in an unauthorized disclosure, always have very significant negative consequences.
Thank you, Mr. Biddle. C'est maintenant Monsieur Villemure.
Now, Mr. Villemure, you have 6 minutes, sir. Thank you, Chair. Considering C-70, what comes to mind is something very positive: confidence, transparency, and work of an exemplary nature. Comparing it to the situation being discussed this morning, the SECU report, of course there's a paradox opposing the need for secrecy and the need for transparency. Ms. Drouin, what's your way of balancing those?
Plusieurs façons de concilier le paradoxe. On a commencé à travailler très fort.
There are many ways of reconciling them. We began working very quickly, knowing that CSE and CSIS meet a number of players and provide public documents to ensure that Canadians are more aware of the various stratagems used by nefarious foreign actors. Transparency, of course, depends a good deal on knowing what these stratagems are so that we can be equipped to counter them. Being transparent doesn't necessarily mean that you have to share all the details, such as names, specific incidents, but rather explaining to Canadians what the risks are, what the threats are, and what the procedures these actors use. So confidence is what we're looking for, of course, and transparency supports confidence. Now tell me, if C-70 were being applied today, given the current landscape, given NCCOP's report, could something be done differently? A number of specific elements will make for quite a difference. The ability on CSIS's part to discuss matters with different levels of government, with the universities, for example, with academia, to provide more information to those players will increase our level of defense across Canada, across our institutions. That's for one. Now, on the criminal level, the various criminal offenses that are being added in C-70 could cover the type of information and capture the type of information that is specified in the NCCOP report. So this will make it easier for police officers and lawsuits and so on to go ahead. All right, so things could be managed better. Is that it? Yes. If preventing foreign interference is something we have done and will always need to do. But the aim here is to be able to detect it more easily. And we know that as we refine our legislative approaches, well, on the other hand, these foreign actors also refine their methods. So what we're doing with C-70 is really terrific work. It's a very much needed first step, but it's an ongoing project. We need to keep working on this together to remain efficient and effective. Now, we'll see how this works out, but I was on the committee that analyzed the Winnipeg lab report. And then I was wondering, because, of course, CSIS was called on to try to carry out some background evaluations of those people, of the scientists involved in that lab. But look, would C-70 lead to something being done differently on that file? You mean information sharing? Yes, and the ability to communicate more fully with, for example, the universities of Canada, across Canada. That, at the very outset, would be really a good step forward, and that could help us greatly to prevent such situations. Same things with our scientists, because when there's like an internal process that's not working, I mean, what didn't seem to be working even before we had to get involved and you got involved. But look, it's also important to point out that, it's a difficult paradox for our scientists, difficult for them to balance things. Science, of course, depends on international collaboration. That's the culture of science, and that's necessary. So we mustn't think that, but we have to work with eyes wide open. Mr. Bilodeau, I like putting questions to you, as you know. The Commissioner's independence, I heard you speak to that earlier, and we've discussed it before. And you've said that, look, it's simpler this way because the infrastructure already exists. But look, you're independent or you're not. It sounds simplistic, but look, I understand the matter of independent action, but responsibility, being accountable for public safety and this gets me back to my comments on transparency, confidence, and exemplary measures. It seems to me that for the government, this is how we must proceed. It must be seen to be this way rather than be sort of a type of independence merely. Thank you for that question, Chair. May I add that the model already exists in the federal government for a commissioner on competition, a commissioner who does operate independently in applying the law. And the legislation as well provides for consultation with parliamentarians, either through the House of Commons or through the Senate. And all said and done, the commissioner can be appointed by the who is appointed can also have their functions removed. It can be destituted, basically. And of course, there may be amendments you wish to include to see to this a little more clearly. And of course, that's up to you to decide, and we'll be happy for any amendments you suggest. But we believe that the bill does allow for considerable independence in the general work of the commissioner and also in the reports they will make to Parliament, which are not sent up to the department or the minister for approval before they're presented to the House. Thank you. Thank you, sir.
Mr. McGregor, 6 minutes, please.
Thank you very much, Mr. Chair. Mr. Vigneault, I take your comments earlier. You know, it's a real struggle that you have from your position, and I think democracies around the world have the same struggle. They may have different systems of government, but there's always an effort to have the legislative branch put a measure of transparency and accountability over intelligence agencies. And you know, in the United States, Congress is a separate but equal level of government, but it is a highly partisan atmosphere down in the United States. But they do have both Democrats and Republicans who are either on the House side or the Senate side, which do have full oversight into the CIA's activities, the FBI's activities, and so on. So it is a struggle. And I know, like in my caucus, we not only have our leader who is cleared for these briefings, but we have Mr. Davies, who's a member of NCCOP. And of course, they're not able to tell us any details, but I think, like, from our caucus's perspective, you know, knowing that they know these things, I think, gives us a certain level of comfort, because they've been able to say that, you know, the issue is serious and that the intelligence community is seized with this issue and regards it as a very important thing. But I guess from your perspective, like speaking as a member of the intelligence community, you know, how is it important from your perspective that we do have key members of both the House and the Senate in the know, even if they're not able to publicly talk about this? Because it seems to me that this is such a serious issue that it should go above and beyond the partisan dealings that we see in the House. We may not be able to speak publicly about it, but to have key members on all sides of the House in the know at least, how important is it from your perspective that that be the case?
Thank you, Mr. Chair, and I think this is one of the most fundamental questions we can talk about. The world is getting more and more complex. The threat environment is making Canada less safe, less prosperous than before, and therefore we need to have different tools and we need to have different mindset in approaching threats to national security. In a democracy, I think it's fundamental that elected members of the House and members of the Senate, in an organized way, have access to the right information in order to be able to inform themselves, hold the government to account, hold the agencies to account through an SICOP, for example. Myself and my colleagues have had to appear many times in front of an SICOP, speak at the top secret level to share details and make questions and challenge on this issue. So I do believe it's fundamental, the democratic environment, to do that. But I also think it's very important. There is one line in the NSICOP report that I think is very important, which is the challenge of intelligence and evidence. It's so the ability of using the intelligence that is collected by CSIS, CSE, and other partners, or shared with us by international partners, and have that used in a judicial proceeding that, you know, will hold people accountable. And that is extremely complex. There are some improvements to Bill C-70, and the government has spoken to the need to do more. But if you're not able to find accountability and create an element of deterrence through a judicial process, Then there are other mechanisms that have been referred to, including for the leaders to have the information and make decisions. It's not going to be a judicial process. It's not going to be someone being charged by a court of law, but it's someone that may not be allowed to run, may not be allowed to sit in a caucus because of the information, the classified information that is being used. So intelligence, absolutely, we need to find better ways to be used in judicial processes, but it also needs to be used for other types of decision-making, because one of the most important elements for foreign actors is when they look at us, and if they see there's not enough consequences for their activities, they will be emboldened to do more. So I think your question is critical.
Thank you. And I think that's a great segue to the RCMP, to Deputy Commissioner Flynn. We've heard the theme of intelligence versus evidence, but more broadly speaking from the RCMP's perspective, could you inform the committee some of the challenges that exist, like when you are in receipt of intelligence, and the challenges that exist for the RCMP then to action on that intelligence, because you have to make considerations as to whether this is going to stand up in a court of law. Can we make a case out of this, et cetera? Can you just inform the committee about some of those challenges?
Absolutely, through you, Mr. Chair. So much of what you've spoken about and the director just spoke about is our reality every day. So we work very closely and collaboratively with CSIS, and frequently we are exposed to intelligence information that we cannot use in judicial processes, in charges, or even in our investigations because of caveats and restrictions on its use. But what it does for us is it makes sure that we are aware of the environment we're operating in. It allows us to look for opportunities that we can exploit to gather information in a manner that can be used in our judicial processes. But I would say even more importantly, what it does is it informs us about the situation, that allows us to take steps that are not just focused on prosecution. And I think sometimes we get caught in a prosecutorial route or process, and we have to look at what our mandate is, and our mandate is public safety, and there are many steps that we can take that enable us to do things that ensure public safety that may not necessarily lead to a prosecution. Many of the amendments that you are studying and proposing in this legislation give us additional powers, eliminate some of the challenges we've had in the past with the ability to prosecute individuals for some of the behaviors. And what I would categorize as the outcome of some of the work you're doing is you are defining what is acceptable and in fact what is illegal in a different way than what has been done in the past. And that will be very beneficial for us.
Thank you, Mr. McGregor. Okay, we'll start our second round with Mr. Cooper. 5 minutes, please.
Thank you, Mr. Chair. Director Vino, what is the highest level of security clearance that a member of Parliament might obtain?
Mr. Chair, there is only one mechanism that exists so far, which is a process to being a member of the National Security Committee of Intelligence and Intelligence of Parliamentarians, NSICOP, and that's a top secret clearance. Leaders of opposition parties have also been offered, but essentially, so we have two processes that exist. One that is very new, but the highest level will be top secret, and then depending on the nature, there might be other compartments added to it.
Okay. Now, I want to ask you that another question to Madame Drouin. It was reported in the Globe and Mail on May 23rd that the Prime Minister and the Cabinet are withholding documents from Madam Justice Hogue, the Commissioner of the Inquiry on Foreign Interference. The article states that PCO, that's you, the Prime Minister's department, told the Globe and Mail that, quote, nearly 10% of Cabinet documents provided to the inquiry have been redacted, and an undisclosed number of other secret Cabinet documents have been completely withheld, end of quote. So how many documents is the Prime Minister's Department, the PCO, withholding from Madam Justice Hogue?
Thank you for this question that will allow me to give a couple of precisions. So far, 42,000 documents have been provided
Now,
to.
how many have been provided? I asked, how many have been withheld?
And so what I can tell you for sure, no incidents, no intelligence have been withheld to the commissioner. We have provided, and this is an extraordinary measures, some memorandum to cabinet, to the public inquiry.
The report, Mr. Chair, through you to Madame Drouin, respectfully, the report states that there is an undisclosed number of cabinet documents. I asked for a number. If you can't give a specific number, can you give a ballpark figure?
So we already said, and now we are trying to refine a little bit, that, and now we are 8% of the documents that we shared with the Commission had some part of redactions
I already said that, but there's an undisclosed number in addition
Mr. Cooper,
to that.
I think you're badgering the witness. I wonder if we could just let her respond.
Thank you, Mr. Chair. So, of course, we haven't shared with the Commission things that were not relevant to her. So it's impossible for me to determine how many documents we haven't shared with her.
Mr. Chair, Madame Drouin, what is relevant to her, Madam Justice Hogue has requested these documents, and the Prime Minister's Department is withholding them. So what do you mean that they're not relevant to Madam Justice Hogue?
We have not restrained any documents that are necessaries for the work of the Commission. She had all the relevant information she needs to do her work.
Who is the Prime Minister?
Mr. Cooper, please let her answer.
No, she's not answering very simply, Mr. Chair. I'm asking her,
I don't have a number
Mr. Chair,
for you.
Who is the Prime Minister who is implicated in turning a blind eye to foreign interference, which has been the subject of the inquiry to determine what is relevant and what isn't relevant for the purview and review of Madam Justice Hogue?
So the relevancy test is being done in comparison of her terms and reference and the mandate she has, and all the relevant information she needed to have in order to accomplish her work, she received that. And if I may give you a little bit of a precision, my understanding of the footnote you are referring to in the interim report of the Commission is whether or not the cabinet confidence that we have shared with her can be publicly
Drouin,
released.
If the Prime Minister has nothing to hide, he would turn over all the documents that Madam Justice Hogue has requested. The fact that he hasn't done that speaks for itself, and I think Canadians can draw appropriate conclusions.
Thank you, Mr. Cooper. The witnesses may answer, if you wish.
Oh, thank you. Well, one thing that I think as parliamentarians, cabinet confidence is really at core of your democracy work. And this is absolutely essential to make sure that, that the decision-making process will continue to work appropriately. And this is not a political question. This is really, at core of our Westminster system, making sure that ministers can share freely their opinion and that cabinet solidarity will be able to maintain. And again, I want to make sure that you're all aware that Justice Hogue received all the necessary information, and the disclosure continue for the phase 3 of our
all necessary as determined by the Prime Minister.
Mr. Cooper, your time is up. But I think we'll call the answer done, and we'll go to Ms. O'Connell, please. 5 minutes, please.
Thank you, Chair. Madame Drouin, I'd like the opportunity for you to actually answer the question because, as we've seen, Conservatives seem to only be interested in their own clips and not actually providing information. Mr. Villemure laughs. I think he'd prefer I make him a sandwich and allow the work to be done by the men in this room, as he had indicated to me. But I think what's important, I'll stick to the actually doing this work as someone who served on NSECOP, who's been looking at foreign interference.
Point of order, Chair. Point of order.
Point of order, go ahead.
Yeah, Mr. Chair, Ms. O'Connell cannot just make outrageous, baseless accusations against my Bloc colleague in this forum. She simply because of a facial reaction to a discussion, she made a vile accusation of sexism
Mr.
against
Dennis.
him. That's unparliamentary,
Mr. Dennis,
and she
that's
should
enough.
withdraw.
Mr. Dennis, it's I get your point, and but it's really not. It's in the debate at this point.
Chair, it is not about debate. It is a point of order about decorum.
I quite understand. Mr. Villemure, I believe, wishes to speak on the same point of order.
Merci, Monsieur le Président.
Thank you, Chair. My colleague here jumped on this faster than I could. I think that the comment was impolite and unnecessary.
See, thank you.
Separate point of order?
Mr. Biddle on the same point of order.
I've called this out before, and he's not the only one, but Mr. Genuis is a frequent one to very much lean into the mic. We do have interpreters here, and like Mr. Genuis, my voice, usually the volume isn't the problem. And so the mic can work from a lengthy distance. We don't have to lean into it to yell into it. So I was wondering if Mr. Genuis can respect the interpreters and just stay back. It's something he frequently does.
Thank you. Different point of order, but well taken. I think we all have a tendency to lean in, and we have to be respectful of the interpreters and their hearing. So, anyways, Ms. O'Connell, please carry on.
Please make sure, Chair, that this didn't take away from my time. Also, if Mr. Villemure may call me impolite, but I think he would be quite embarrassed if, and Mr. Genuis may not have defended him so clearly if he had heard some of the comments towards me while we were suspended. But I'll move on to the actual work of this committee. And through you, Mr. Chair, to Madame Drouin, you spoke about, and I think this is an important point that should be noted and understood. You mentioned something about, in reference to Mr. Cooper's questioning to Madame Hogue's inquiry and the request for additional documents, and you said something about a footnote in that request. Can you please elaborate on that answer? Because I'm actually quite interested in what you were referring to.
So I think that in the footnote, the report says that the conversation on cabinet confidence is ongoing. And this is, my understanding of the situation about that is not whether or not she should receive more, is how she can use publicly the cabinet confidence documents that she has received.
Earlier in the questioning, Mr. Caputo, and this can be to Mr. Vignon or Madame Drouin, whoever is best suited to answer it, insinuated that, for example, anyone who receives a security clearance members then can no longer do work in areas of topic of, for example, foreign interference, if their clearance has allowed them to do that work. Myself and Mr. Motz have received security clearances and worked on the 2019 foreign interference review of NSECOP, yet here we are asking important questions, raising important issues, and not breaching the indoctrination requirements that we signed, that we are committed to for life. It's not just at our time on NSECOP. And I also found it quite interesting that Mr. Caputo, in a way, was trying to justify why his leader wouldn't receive a security clearance, because then he would be muzzled to ask tough questions, yet the legislation and the law that would restrict his disclosure of sensitive information was the very thing that just the hour earlier, Mr. Caputo was asking Minister LeBlanc to breach. Is there a difference of law or legislation that applies to the minister or cabinet that would apply differently somehow to myself, Mr. Motz, the leader of the NDP, the leader of the opposition, once they receive security clearance?
Mr. Chair, the law applies to everyone the same way, including to elected officials who may have the right security clearance to receive information, or to officials in government who are also bound by the law.
And it was also suggested, I'm assuming Mr. Caputo was referring to SOIA, but the Secret of Information Act, but he didn't specify. He suggested, and I wrote it down, that the minister can release secret information if it's in the public interest. I would have signed, Mr. Motz would have signed the same indoctrination papers, the same legal requirements once you receive sensitive or clearance, and then once you receive sensitive information. Nowhere in there have I ever read that there's a caveat that the minister can unilaterally disclose sensitive information or somehow declassify, which is usually referred to in the U.S., declassify some information that he deems appropriate. Am I missing something? Is there some magical law that the minister himself can determine what can or can't be shared publicly? Because I think that insinuation is quite important that Mr. Caputo is making.
So that'll be the end of your questions, Ms. O'Connell. I'll let the witnesses answer, please.
Bill C-70 includes a new provision that would clarify an ability to disclose personal information when it's in the public interest and that interest clearly outweighs any invasion of privacy that could result from the disclosure. And this is a corollary to the broader provision that would allow for the disclosure of information to build resiliency to threats to the security of Canada. It doesn't exist now. It's in this bill.
Thank you. We go now to on y va maintenant, Monsieur Villemure.
We'll now take Mr. Villeneuve for another 2.5 minutes. Thank you so much, Chair. Ms. Drouin, let me give you an analogy. You go on a website, you can click to choose cookies and so on, or refuse them, and I tend to say those that are absolutely necessary. So, regarding when I was discussing this with the Privacy Commissioner, I said necessary for who? And they said information necessary to those who are analyzing the information. That's why the whole public inquiry requires documents that are necessary and relevant. But necessary and relevant to whom? Just like, cookies necessary for whom when I click on when I'm up on the internet. Now, document classification. The Winnipeg lab, we saw that there was excessive classification, about a couple of hundred pages. That was obvious. And this excessive classification, too high a level of classification, is of highest concern to me, whatever government is in power. Do you think that reports such as that as NCCUP could also be suffering from just overclassification? With NCCUP and other such high-level groups, there's a very sophisticated process now affecting their reports. They do put out classified reports, and then there is exchange with CSIS teams in particular to decide, and it's really a matter of balancing the various interests, deciding what can be made public, what can't, could a summary be published, and so on and so forth. So there is a specific way that the specialists go about this, which is, straightforward. One of the agencies could say, I think it would be in the public interest to say more, and NCCUP might say, no, we think we should protect this, and so on. There's a discussion. So this leads to a balanced decision and a balanced approach, which changes over time. I interrupt you, I'm sorry. I have little time. Do you think that overclassification is a problem in general? Not necessarily. Sometimes there may be, kind of a reflex. Okay, we must make this secret, and it needn't be. And these are issues we deal with on a regular basis. Of course, the example of secrecy is a very good one, yes. But getting back to your example of the Winnipeg lab, I think that we have to keep in mind the context. Sometimes it can be easier to make things public when the risk has already been reduced. And that was what is aimed for in the new information sharing about the Winnipeg lab. Thank you. Thank you.
please. 2.5 minutes.
Thank you, Mr. Chair. Mr. Bilodeau, I appreciate your earlier answers on the many questions you've received on the definition of arrangement. I just want to read, the committee is in receipt of a letter from Canada's research universities, and I just want to quote something from their letter. They said, quote, greater clarity is needed on how an arrangement will be defined under the Act and whether it would capture research partnerships, funding agreements, or other international research activities conducted with publicly funded universities, research institutions, or foreign research funding agencies, which may be considered foreign principles under the Act. The risk of a chilling effect on international research partnerships as an unintended consequence of the registry's reporting requirements could significantly harm relationships with international peers and mean that Canada misses out on the opportunity to cooperate on cutting-edge research and access to world-leading expertise with peer nations. I just was wondering, sir, if you could comment on that concern that they've raised with the committee.
So I haven't had an opportunity to read that letter, Mr. Chair, but here are a few reactions. One is the Foreign Influence Transparency and Accountability Act doesn't prohibit any activities. It just requires transparency about certain activities. And so having said that, any agreement or any situation must be looked at through the lens of what is required to be registered, and that is an arrangement with a foreign principal to do one of the three activities that is enumerated in the legislation, and it has to be about a government or political process. It's only when those three are met that the registration obligation is triggered. And therefore, part of the Commissioner's mandate will be to inform what is captured by that. And you can imagine a scenario where a university partners with a foreign university that may be publicly funded to carry out research about a specific topic, but if it's not about a government or political process, then one of the elements is meant and doesn't trigger a registration obligation. And so I think it's important to really always look at it through the lens of the three requirements, because we're not looking to chill anything or expression. It's just about being transparent about those very specific things that are enumerated in the legislation.
And just very quickly, Chair, as you said, further nuance can be spelled out in the regulations, and the Commissioner will have some authority to make some nuances as well, correct?
That's right, and we would expect a Commissioner, when he's developing or they are developing guidance, to engage with the appropriate stakeholders in consultations.
Thank you, Mr. McGregor. So I think we'll have to call an end to this panel at this point. So thank you to all the witnesses for being here, and some of you for a couple hours. Appreciate that. And thank you for making yourselves available on such short notice, and for all of your great answers to help us in our study. So that being the case, thank you all, and we are suspended. Bring in the next panel. I would like to welcome the witnesses for our last panel on C-70. From the Office of the Intelligence Commissioner, we have the Honorable Simon Noel, Intelligence Commissioner, Justin Dubois, Executive Director and General Counsel. From the National Council of Canadian Muslims, we have Ahmad Al-Qadi and Nusaiba Al-Azem by video conference. And as an individual, we have Marcus Kolga, Senior Fellow, Macdonald Laurier Institute, also by video conference. So welcome to you all. I will invite Mr. Noel to make an opening statement of up to 5 minutes, please. Go ahead, sir.
Thank you, Mr. Chair. Merci, Monsieur le Président, Mesdames, Messieurs.
Thank you, Chair, ladies and gentlemen, members of Parliament. Thank you for inviting me to discuss Bill C-70 with you. I have with me today on my left Justin Dubois, Executive Director and General Counsel for my office. The role of Intelligence Commissioner was created in 2019. I have been in this role since October 2022. So, in a nutshell, my mandate is to approve or not certain national security and intelligence activities that are planned by either the Communications Security Establishment, the CSE, or the Canadian Security Intelligence Service, CSIS.
CSIS and CSE may sometime engage in activities that could involve breaking the laws of Canada or interfering with the privacy interest of Canadians. These activities are authorized by the Minister. The Intelligence Commissioner, who I will refer to as IC, reviews the Minister's reasons to determine whether they meet the test of reasonableness as recognized by the Canadian Court. If reasonable, the IC approves the authorization and the agency can proceed with the planned activity. My written decisions are binding and redacted versions are published on our website. A number of ministerial authorizations that are subject to the IC's review relate to the use of data sets. The IC's main role relating to the data set regime ensures that CSIS exercises its authority to collect non-threat related information about Canadians and persons in Canada in a balanced manner, and that the Minister has given proper consideration to privacy interests. Independent oversight, in my mind, is crucial. Bill C-70 proposes certain amendments to this dataset regime. Most of the changes are intended to facilitate the use of the dataset regime for CSIS. Overall, I am of the view that the proposed amendments will not change the nature of my role of conducted independent oversight. Cela étant dit,
So that having been said, I would like to highlight a few proposed amendments that nonetheless would have an impact on the work of the Intelligence Commissioner. First of all, the bill would authorize CSIS to collect and retain data sets for the purposes of Section 15 of the CSIS Act. Section 15 allows the service to conduct investigations for the purpose of providing security assessments to the Government of Canada. So this would broaden the scope of the data sets that CSIS can collect, data sets which would implicate Canadians. This addition might raise new concerns, which I would have to consider in quasi-judicial reviews. Second, the bill would allow CSIS to disclose foreign data sets which have been authorized for retention. The conditions for the disclosure of these data sets would need to be clarified. It's possible that this element could be considered by the Intelligence Commissioner when reviewing the reasonableness of ministerial findings. Third, there are some changes to the validation period for ministerial authorizations.
Changes because I think they are most consequential and to help explain how the dataset regime is operationalized. The IC's oversight role is limited to data set falling within Section 1, that is the collection of personal information that is not directly and immediately related to the threat to the security of Canada. Bill C-70 makes it clear that CSIS will make use of the data set regime only when the data set cannot be collected through other jurisdictional means. I'm here as Intelligence Commissioner, but I carry My baggage of experience, as you can see my age, as a designated judge of the federal court for 21 years, as well as counsel involved in national security matters and commissions, the first one being in 1979, the MacDonald Commission on the FLQ crisis in Quebec, and the reform that brought along the CSIS that we know today. I look forward to answering any questions you may have. I may add, just before I finish, as a judge, I was involved in data sets regime, the within-outside Canada regime, something you have in front of you today, and fine-tuning the role of the special advocate involvement in Section 38 Canada Evidence Act proceedings. Having said that, I'm open to any question you may have if that can be helpful to you. Thank you. Merci, Monsieur le Président.
Thank you, sir. I now invite Mr. El-Kadi to make an opening statement of up to 5 minutes, please.
Thank you, Chair. Good morning. My name is Ahmed Al-Qadi. I'm joined by Nusayb Al-Azim, Director of Legal Affairs for the National Council of Canadian Muslims. We are here to offer submissions on Bill C-70. Let us begin by noting that many of the goals in the Act are laudable. In fact, more than 4 years ago, we testified in front of the Foreign Affairs Committee on the need for Canada to crack down on foreign agents from any nation, given the clear intimidation that Uyghur Canadians were facing from China state agents. We are deeply troubled by the numerous reports of interference from foreign states, including the governments of India, China, and others that have a pattern of engaging in crackdowns on minority communities. We are in full agreement with what many others have stated before you in this committee. Canada must take action to challenge foreign interference. That's why we have clearly supported pieces in this legislation, like the Foreign Agents Transparency Registry. That being said, while there is much that is good about this Act, we must first note as clearly as we can that rushing to pass this bill in its entirety would be problematic. When we're rushing to make changes to our national security legislation that have fundamental impacts on privacy legislation, and when we're further empowering agencies like CSIS that numerous judges have cited for their problematic behavior, and when there has been no real time for academics or civil society actors to review the legislation, respectfully, there is a high likelihood of arriving at unintended consequences. Even today, in offering our initial response to the legislation, we doubt that we'll be able to provide a fulsome answer to all of the questions posed, given that we only received a technical briefing on the legislation from government officials yesterday. Moving too fast can impact everyone negatively. Our national security agencies have in the past erroneously targeted Christian social conservatives, environmentalists, Sikh communities, Indigenous communities, Muslims, progressives, and everyone in between. And that's why we believe more time is needed to conduct a fulsome study with academics and experts that isn't crammed into 1 week. Our first and most important recommendation, therefore, to this committee is to split the bill and pass what most have considered to be strong and relatively uncontroversial through the passage of Part 4 of C-70, and to study the rest of the important suggestions laid out in the bill in a far more thorough fashion. Thank you, and I will turn it over to my colleague, Nusayb.
Thank you very much. Ahmed is indeed right. A number of provisions require further study. For example, under Part 2, Section 20 of the Security of Information Act, SOIA, there's an amendment to add the language of intimidation, and I quote the Act, "Every person commits an offense who, at the direction of or for the benefit or in association with a foreign entity or a terrorist group, induces or attempts to induce by intimidation, threat, or violence any person to do anything or cause anything to be done." However, and this has been raised before for this committee today, intimidation is not defined in the SOIA, and this is hugely problematic. Are we using the tort definition or relying on parallel criminal code uses of the concept of intimidation, or another definition entirely? This ambiguity could be used by this or future governments to target different kinds of protest activities that some have accused of being foreign funded, whether it's convoy protesters or Black Lives Matters protesters or others. We recommend that this section be deleted in its entirety or that intimidation be clearly defined in the Act to ensure that there is a civil liberties carve-out similar to the proposed carve-outs in Section 60 sub 2 and Section 61 of Bill C-70. The Act also, in Part 1, expands substantively on CSIS powers. This expansion of CSIS powers for what they propose will help them adapt to changing technology beyond Canada is a significant change that deserves study. Changes around surveillance and warrant procedures as well deserve significant study. We are also concerned about the expansion of the inadmissibility provisions of the Immigration and Refugee Protections Act, IRPA, the sabotage provisions, and many others. The new IRPA provision, for example, suggests that the minister may be able to find you inadmissible if the minister deems that you're bad for Canada's, quote, international relations. How would this impact dissidents from dictatorships that Canada has diplomatic relationships with? So this legislation has many complex implications. And appropriate due diligence is not being exercised when it appears that all parties with what we view as good intentions are inadvertently rushing to make significant changes to our national security infrastructure without adequate checks and balances through a longer, rigorous, and informed studies. And subject to any questions, those form our submissions. Thank you.
Thank you. I now invite Mr. Koga to make an opening statement of up to 5 minutes, please. I can't hear you.
There, how's that?
Much better.
Perfect. Thank you, Mr. Chairman, honorable members of the committee. I'm a journalist and civil society activist who's been researching and exposing foreign information and influence operations targeting Canada and our allies for nearly 15 years. I'm also a human rights activist, and through this work, I've had the privilege of supporting and collaborating with extraordinarily courageous champions of democracy and human rights, some of whom testified before this committee earlier this week. Others have faced intimidation or detention for speaking out against the totalitarian regimes in Beijing, Moscow, and Tehran. Some have been poisoned, and others brutally murdered for their activism and advocacy. For my work in supporting many of those brave activists and our common causes, I've directly witnessed and experienced the chilling effects of foreign authoritarian transnational repression. These include death threats, harassment, and defamatory articles regularly published by Kremlin-controlled media outlets against me. Kremlin-aligned influencers and proxies in Canada have attempted to discredit and silence me through psychological intimidation and whisper campaigns. And while my personal experiences are less severe than those of witnesses you've heard from earlier this week, such as the brave members of the Uyghur, Tibetan, and Hong Kong communities, the objectives of these influence operations are universal: to repress the free and open expression of regime critics within the Canadian political and media environment, and ultimately to undermine our democracy. These operations aim to cast doubt on the credibility of their victims. Tactics may include malicious online articles or poison letter writing campaigns containing false accusations about the targets sent to media, government officials, and even the victims' employers. In my case, such campaigns were carried out by Canadians working with Russian companies, trade promotion organizations, and Kremlin-controlled think tanks. The psychological impact of being targeted and then defending against such foreign influence operations is, by design, exhausting. Victims feel isolated and defenseless. Concern for the safety of family members creates additional psychological stress, all of which is made worse when these campaigns include threats of physical violence. This can lead to significant psychological trauma and further problems. Ultimately, the target becomes so overwhelmed that they give up and silence themselves, limiting their ability to freely express themselves. The lack of a coherent support system for vulnerable communities compounds the problem. In 2019, when my family and I were targets of death threats sent from a Moscow-based IP address and on social media, no law enforcement organization was equipped to comprehensively deal with the issue of transnational repression. When I called my local law enforcement unit, they told me to contact the RCMP. When I contacted the RCMP, they told me to contact CSIS. CSIS is, of course, a dead end. When C-70 comes into force, all parliamentarians need to support the development of policies that provide meaningful support for vulnerable communities and the brave activists and journalists who become victims of transnational repression. For Canadians vulnerable to transnational repression, C-70 is a welcome ray of hope in our common cause to defend our democracy against authoritarian regimes that seek to undermine it. The transparency and accountability required by the Foreign Influence Transparency Registry will help ensure that dishonest Canadians who are lured into the service of foreign authoritarian regimes with lucrative opportunities are identified. This will allow government officials, media, and vulnerable communities to be aware of who and what these individuals publicly represent. When properly enforced, this new law will help prevent them from manipulating our political and information environment. However, I believe that the Act would be further strengthened by a definition of both physical and digital transnational repression, and that such activity targeting vulnerable diaspora communities and human rights and pro-democracy defenders should be included in the Act and the Foreign Influence Transparency Registry. Our foreign adversaries spare no expense in their efforts to undermine our democracy. Until now, they've manipulated our information spaces, influenced policy, and intimidated our brave frontline defenders of democracy with relative impunity. Properly implemented and enforced, C-70 will end their impunity and provide a new bulwark to defend our democracy. Thank you.
Thank you, sir. So we'll now start our questions with Mr. Jennis. Mr. Jennis, please go ahead, 6 minutes.
Thank you, Chair. We've got a great panel again today. I'm going to start with the National Council of Canadian Muslims, and hopefully I'll get on to others, but I know how the time can fly. I really sympathize with some of the points you've made around timing. Full disclosure, we have on our side been pushing that this bill be passed quickly, but this bill should have been proposed much earlier. I think we should have had legislation on foreign interference in front of us years ago, and that would have allowed us more time. There is urgency because we need to protect the next election. We need to ensure that some of these provisions, which take time to implement, are in place before the next election. We don't have the same kinds of problems. But there's the study happening here. There's also the study happening in the Senate. I think the Senate's already doing pre-study, so that's an opportunity as well for you and other groups to engage and put forward suggestions. I'm very glad you raised Division 3, the IRPA changes, because this is not something that I think has been a subject of discussion yet at all. I don't know that we've had immigration officials before the committee. Hopefully they'll be here for the clause by clause portion, so that people who have questions about it. What is your understanding about why language would be inserted that allows for inadmissibility on the grounds of international relations? Obviously, national security, national defense makes sense, but I would think. Almost any dissident or refugee who would come to the country would have some effect on our international relations with the country that they're fleeing from, and it does seem pretty broad. What do you read into that?
I'm happy to answer this one. Thank you very much for the question. And I also, just on a personal note, want to say what an honor it is to be able to testify alongside former Justice Noel, whose decisions I read many, many times in law school, so over and over. With respect to IRPA, our primary concerns, obviously, is around that piece that you identified about the minister deeming that if somebody's injurious to Canada's international relations, because of precisely how you've identified that it can be overly broad. What does that mean, right? International relations has also, pursuant to the bill, been added to the criminal code here, but it's not defined. So does that mean dissidents from dictatorships, but that dictatorships that Canada has diplomatic relationships with could be impacted? Again, our primary concern here is not with the potential application of the rules in principle, but rather the lack of definition included in some of the language that could cause undue harm. And so we have to emphasize that the legislation has implications on so many facets, and we're concerned that any kind of rush and understanding that... Oh, go ahead.
Thanks. Sorry, I'm going to jump in. I have another question. It's back to you. I want to ask about the issue of political discrimination. I believe that we should want to have a country in which people are free to express their political views without fear of intimidation or other kinds of consequences, employment-related consequences, other kinds of consequences in their commercial relationships. And that's why I proposed a private member's bill, C-257, that would add political belief and activity as prohibited grounds of discrimination in the Canadian Human Rights Act. I'm concerned about how foreign interference can play a role in political discrimination as well, how foreign interference may manifest itself not necessarily as direct threats of violence, for example, but it may manifest itself as pressure on institutions to not hire certain people, to remove people or limit the participation of people who may be expressing political views that are not in line with the interests of that foreign state. And I know this is an issue that I've discussed on a few fronts with you folks at NCCM. Could you share a little bit your thoughts on the issue of political discrimination and how we might combat it through legislation or otherwise?
Who's
Sure,
that?
I'm happy to.
Go ahead.
Sorry, I'm happy to. With respect to political discrimination, this kind of goes back to the point. This speaks, I think, a little bit to that part 4 and why we support the transparency of a registry that allows for everybody who could potentially have every agent that could potentially be undermining Canada's democracy or sovereignty, whether an ally or not. And it speaks again to that important piece about not having, about not rushing the other pieces that could potentially be used to undermine, like for example, civil rights groups and people who are protesting, whatever it might look like, that should have the ability to be able to exercise that political division in our nation. Does that answer your question?
Yeah, thank you. And just in the last 30 seconds I have, Mr. Kolga, if the government is concerned about foreign interference, why haven't they expelled more Russian diplomats? What is your view on the expulsion of Russian diplomats and what they may be up to while they're here in Canada?
Well, I mean, we don't know exactly what those Russian diplomats may be up to, but it's probably no good. We know that Russia uses its diplomats to engage in intelligence operations and influence operations, and we know this through the reporting of Canadian journalists who have reported how they try to pitch various disinformation stories to Canadian journalists, disinformation and such. And so I would absolutely favor reducing the number of Russian diplomats in Canada. Right now there are up to 80 of them. I don't know what 80 Russian diplomats in Canada would be doing other than engaging in potential foreign interference.
Thank you, Mr. Dennis. We go now to Mr. Gahir for 6 minutes, please.
Thank you, Chair, and thank you to the witnesses for appearing before the committee. My questions are for the Intelligence Commissioner. Sir, it's an honor to have you at committee. Can you, and you did this in your opening testimony as well, but can you please outline the relationship between your office and CSIS?
Well, thank you for the question. CSIS has a jurisdiction to collect data sets, and as a result of that, the IC intervenes in making sure when the minister authorizes or the director authorizes. Secondly, I just want to give you an overview of the jurisdiction. Human sources acting across Canada on behalf of CSIS can do certain activities and not others. They can commit illegal acts in order to pursue their investigation. I'm involved in reviewing the category of acts and omissions that these human sources can do in the field. My relationship with CSIS goes back to 1984. I was involved in the complaint process with the predecessor to NCIRA. I've followed the work of CSIS through the years, and more as a judge, I dealt with hundreds and hundreds of warrants application, certificates being issued, and Presently, I have this oversight review to do with them, and if you want me to say how I qualify it, I think I'm having a professional, serious relationship with them. We relate, we disagree, we agree sometimes, and I say so publicly as my decisions can test.
Sure. So when that review happens, is that review subject to a reasonable standard?
Yes.
Is it the Vavilov standard?
Yes, it is.
It is. Okay, so I'm not trying to relitigate Vavilov in the subject of this committee in the 5 minutes that I have, but do you think that the Vavilov standard of reasonableness, where deference is given to admin agencies, is that a high enough bar for the sensitive information that CSIS deals with?
My interpretation of the Vavilov decision on reasonableness is the following. Yes, the decisions have to be sound, factual, based on the facts of the case, and the decisions also must take in consideration the privacy of Canadians, our privacy. And I insist and I get involved. Deference, for me, has a limit. If I see something's wrong, like I did in one decision, I refused completely what CSIS was asking. They came back a few months after, they reviewed the situation, and they presented a completely other file, and I agreed with it. So, in essence, to be clear, your question is valuable in law. What I'm saying, reasonable is, in the way we're applying it, takes in consideration deference, but not to the limit of being a servant of the decision maker.
And Chair, how much time do I have?
Minute and a half.
Okay. So thank you for that. So it is a very robust standard. And is it correct that CSIS can't conduct certain activities without your prior approval?
Well, not my jurisdiction is limited to the jurisdiction I have. I'm reviewing minister's decision that gives the power to CSIS or the authorization to do certain acts and things like that. It is true that if I disagree, they cannot in relation to the jurisdiction I have. If I come to the conclusion that the application as presented to me is unreasonable, they either go for a judicial review, which they did not after 14, 15 decisions up to now, or they come back and correct their application.
And this is for the very high level decisions, right? This is not every decision that CSIS is making that you're reviewing.
No, I don't have the jurisdiction as to their work on a daily basis. Yeah. I'm there in the principles that are being applied to the work that they have to do.
Great, thank you.
15 seconds. But okay. Thank you. On y va maintenant, Monsieur Ville.
And now to Mr. Villemur for 6 minutes, please. Thank you very much, Chair. Mr. Noel, you are a commissioner of an organization that I'm only sort of familiar with your role. So we've been discussing how the commissioner for foreign interference would be appointed, and we've been talking about the independence of that person, but that person would also answer to the Minister of Public Safety for organizational reasons. Is that the case for you? Well, the commissioner is, but my role as commissioner specifically is quasi-judicial. And to that extent, I consider myself to be independent. And I'll explain how, Mr. Villemur. Under the Act, the Commissioner Act says that I can get briefings. I can't be familiar with all of the technology that applies in this world of intelligence gathering, etc. And so what I've done since the beginning, in October 2022, I met with Mr. Vigneault, and I told him the following. If you want to brief me, you will choose the subjects. And if ever, one day, I have to render a decision and I don't have the information that I need to make an informed decision, well, it's too bad, but I'll declare it to be unreasonable. So I've transferred the burden of proof to CSIS. So I consider myself to be very independent. The Act gives me incredible power. I can tell CSIS, stop doing such and such a thing. I can also say the same thing to CSE. And so to that extent, I am aware of the importance of the decisions that I make. But if I were to realize that the decisions that I'm making will have an impact on somebody's privacy, I wouldn't hesitate, and I've never hesitated so far. Do you believe that in the wording of the Act, the position proposed for a commissioner for here is sufficiently independent, the Foreign Influence Transparency Commissioner? Because there is accountability to ministers, so is it sufficiently independent? Well, it would depend on the person who would be in the position. I'll be very honest, I haven't read the exact wording that you're referring to in the bill here. I can say that from my point of view, I don't report to anyone except to myself. The Privy Council is the organization which, is sort of the umbrella organization, but my decisions are my own. I have the impression that anyone who's in my position will work the same way. If I look at the Privacy Commissioner, for example, and the way that he operates, he is independent. And if we put in place, parameters to say, oh, you'll be independent or super independent, I'm not sure. I think that it's what happens on the ground. It's how the work is done that's important. But I'll go back to what I said at the beginning. I haven't looked at the wording exactly that's in the bill here, but I can speak to my own position. Now, thank you. I appreciate your candor. So I understand that, you can be independent or not. And I'd like to move now to ask you a question about the concept of secrecy and the necessary for secrecy in certain contexts and the necessity for transparency at the same time to make sure that there's confidence. So how do we deal with that? Well, I've been thinking about this since 1979, and I've gotten into the habit, and for the moment it works, of having a wall, if you will, which allows me to speak to people. A lot of people are curious. Oh, what is it you do, etc. I was a judge. Same thing with I had to deal with these same sorts of questions. So to go back to the specific question, how can secrecy and transparency work at the same time? Well, at the beginning of my mandate in October 2022, with my colleague Mr. Dubois, we said, listen, we're going to publish our decisions. We're going to make them as clear as possible and as transparent as possible. And that was our test. And it's still the test. We have constant discussions about what goes out. We don't want to have summaries. We really want to make sure that the exact wording of the decision can go out and be made public. And I think that, as a good Canadian, it's push and shove, and there has to be some of that. But, I do have privileged access to some secret information, And my point of view is that that information has to be protected. It's not hiding something for the sake of hiding something. There are lives that are at stake. There are operational techniques that must be protected. Because, how could I put it? We can't go to war because we are at war right now. Cyber attacks, things like that. That is a form of war. It's a new form of war, and you can't go to war with wooden swords. You have to protect the information. That information has to be protected to make sure that our agencies, our intelligence agencies, have the means to fight back against other countries which don't have the limits that we have in Canada. The only thing that I insist on constantly is that there have to be organizations like the Office of the Commissioner, oversight organizations, and like the civilian oversight as well, which looks at what's happened after the fact and then publishes decisions, and like NSICOP as well, the Oversight Committee of Parliamentarians. And I've read their report. I read the report about the trip to India where the MP was present, and I'm impressed by the work that they've done. It's an incredible burden that we're putting on their shoulders and on our collective shoulders. But Mr. Villemot, I'll say very honestly, I've been working on this since 1979. We are able to do this. And in terms of the climate of secrecy, it's being pushed aside, and more information is coming out. The recent report from NSICOP, for example, is the clear example of that. Sorry, we're out of time. Thank you very much.
We'll go now to Mr. McGregor, but I would like to advise the committee right off the top that Mr. Kolga has to leave us at 1:15. And so if you have questions for him, you should make them sooner than later. So Mr. McGregor, please, 6 minutes.
Thank you, Mr. Chair. Commissioner Noel, I'd like to direct my first questions to you. The first part of Bill C-70 makes some pretty consequential amendments to the CSIS Act, notably massive upgrades to the CSIS dataset regime. We've kind of been describing it as bringing in analog law up to speed so that it fits in a digital age. However, I've read the NCIRA report on CSIS's use of the dataset regime, and it's littered with comments like CSIS's current application of the dataset regime is inconsistent with the statutory framework. CSIS did not comply with the dataset provisions in the CSIS Act. There was non-compliant information held, and CSIS has failed to adequately operationalize the dataset regime. So that's a pretty scathing report. And now I'm being asked as a legislator to fix the dataset regime, give CSIS more powers, but that's in the context of them failing to act by their current statutory obligations. So I guess from your point of view as a commissioner, what can you tell me as a legislator that would put my mind at ease that a few years down the road from now, I'm not going to read another NCR report that shows that CSIS has blown past the statutory limitations I'm now being asked to give it here and now?
Let me answer in the following way. I deal with data sets that are not threat related. Anything else that they would like to have in relation to Canadians or foreign data set will come one way or the other to the Commissioner's office. That's my part. CSIS collects under its jurisdiction, Section 12, Section 12.1, Section 15, which they want now, and Section 16, collects data set as long as it relates to the threats that they are investigating. Having said that, if they want to collect, they have to meet the threshold of Section 12, Mr. McGregor, which is strictly necessary. NCIRA did a report, I think it goes back to 2019, And if you look at it, it's an earlier report. It was the beginning. I have seen some policies recently on how they operate. I wasn't asked, and that's not my jurisdiction. I wasn't asked to deal with them, but they appear to be, to me, serious. I'm looking forward, in order to appease my concern, as I read this report just like you, to a new report of NCERA that will update its earlier report and tell us how exactly this will operate.
I appreciate that. Thank you. I want to direct my next questions to the NCCM. I appreciate the concerns that you have outlined with this bill, and certainly from this committee's perspective, this has been a busy week for us as we dive deep into Bill C-70. I take note of your concerns with the definition of the term intimidation in the proposed amendments to the SOIA. I actually did have a chance to ask the Minister of Justice a question about that. I don't think I got a direct answer to my concerns, except he said something, and I'm paraphrasing, that it would only be when there's an element of foreign interference and not lawful and proper protest, but really something that's attempting to influence Canada and subvert Canadian interests. And I would note, too, in the existing SOIA, under Section 24, the Attorney General is needed the consent of the Attorney General is needed to prosecute any offense of the SOIA. So I guess from your perspective, what definition of intimidation would the NCCM like to see put into this bill?
First of all, we do want to acknowledge all the effort that's been put in this past week by this committee to ensure that Canada gets the robust and fair foreign interference legislation that it needs and deserves. In regards to the definition of intimidation, again, our primary concern is that it's not that it's ill-defined, it's simply not defined. So in regards to what we would view as a sufficient term of intimidation, I truthfully can't speak to that at the moment. We'd have to, again, conduct a more robust review ourselves of the bill. But our primary fear is that, as Nusayba mentioned, if the bill was passed tomorrow, a current government could identify protest activities that they just don't agree with and penalize them under the pretense that they're aiding a foreign entity. And it could be, the lack of definition opens up the doors for usage on both sides of the coin. You could have a government that would penalize convoy protesters, or like Nusayba said, Black Lives Matter protesters. So we are happy to provide recommendations in regards to what the definition of intimidation would look like, because in our technical briefing as well, we didn't really get a direct answer. There wasn't an outlined definition of intimidation, so we'd be happy to provide that further later on.
Yeah, and I just want to note quickly, most of the bill will come into force within 60 days of royal assent, which is a pretty tight timeline. The only part is Part 4, which is really open to a date set by the Governor and Council. So I think that just speaks to your proposal to split Part 4 off of the bill from the remaining parts. Just wanted to note that for the record.
Thank you, Mr. McGregor, and the witness may answer if you wish.
Oh, no, yeah, I appreciate that. Thank you.
Okay, thank you. Okay, we'll start our second round with Mr. Motz. 5 minutes, please.
Thank you, Chair, and thank you very much for our witnesses for being here. I think most of the questions that I would like to relate to today would be for a response from all three of our witnesses, our sets of witnesses. And the first one is this new act now will give some additional powers to CSIS to share information. So it may not be, from your role, Commissioner Noel, as well as from yours, Mr. Al-Kadi and Mr. Kolga, a different perspective. But Commissioner, do you think that these data sets will work? Not the data sets, the information sharing powers that they've been expanded. Will they work? Will they do the job that they're intended to do? And for your community,
And from what you see, Mr. Kolga, would these new power sharing proposals give more protection to those communities in this country that need that sort of protection? And I'll start with you, Mr. Commissioner Knoll.
Thank you. The dataset regime is on since 2019. It has been operational. What they have done now is fine-tuning, really, the legislation. Give you an example. An authorization is good for a year. They have asked for 2 years. Fine, okay. My prediction is that in between there'll be amendments. As for foreign data set, 5 years to 10 years. This is fine-tuning.
I may not have explained it well. What I'm getting at is they have new powers to share information with those that are going to be impacted by foreign interference, right? And the question is, does it go far enough? And will it protect the communities in this country who experience the threat of foreign interference?
With that bill, I will be involved. I will be reviewing whatever they intend to do with the transfer of information. Will that be helpful? I don't know. Until we see the reality in the field and how it's actualized, it's hard to predict. Is it good that they can transfer? Having an insight in that world, I can tell you that between the Five Eyes, it is most important that there be exchange.
Mr. Al-Khadi?
Yeah, so we believe that sharing information with communities that are targeted is crucial, is important to make sure that those communities are able to protect themselves. I'm not too familiar with the tragic case of Harjit's signature, but I would imagine had there been more communication from our security intelligence agencies, he might have been able to be protected. So on face value, I would say yes. I think we believe that it would provide more safety to the communities, but we'd have to, the devil's in the details, that's the saying, right? We'd really have to investigate deeply how that would be done, who else it would be shared with, and ensure that there are safeguards at all times so that, privacy information is not leaked. And, I'll be honest, speaking from the perspective of the Muslim community, it's not the best relationship with CSIS. So there is a need to build trust due to the, problems in the past that have been made very public with the NSIRA report that was that was released a couple years ago. Does that answer the question?
Thank you. Mr. Kolga?
As a human rights activist and being active within communities that have been targeted by transnational repression, I think it's critically important that CSIS have that ability to have that two-way conversation, to pass that information that is in the interests of safeguarding our safety and our democracy. And having briefly sort of reviewed the legislation, I mean, it's clear that there safeguards have been put in place. The safety of that information and privacy have been taken into account. And so I think this is one of the more important parts of this legislation. And it's one that, again, I as a human rights activist and, again, the community that I work with are very happy with.
Okay, well, thank you very much. And I'll go back to you, Mr. Kolga, first.
Mr. Motz, thank you. 5 minutes. We go now to Ms. Saeed. 5 minutes, please.
Thank you, Chair. Thanks to all the witnesses for appearing before the committee. My first question is for Mr. Knoll. We have seen in the past that national security legislation, especially when passed quickly, can lead to unintended consequences, especially for members in the minority communities. These same communities, which are most often targeted by state actors for foreign repression, have often felt unfairly targeted by intelligence and security agencies. So could you share what the intelligence agencies are doing to build trust with these communities, especially as they seek expanded powers in C-70?
I'm not too sure I can help you on this because I never was within the agency's organization. The closest I come to it was when I was counsel to the predecessor of NCERA in complaints. And I knew a good number of complaints about how from communities where they, because of identifying a community, they would knock on doors. But that goes back to 1984, 1990. I think they've improved drastically. There's still a long road to go. I think the process of establishing now, potentially in this legislation, the fact that they will be able to get out of their little hidden barracks and start talking to people will help tremendously. I think the more also that they'll employ people from different groups will help tremendously. But this is an ongoing, I'm sure for CSIS, an ongoing project, and they need to improve on that, and it is very important.
Thank you. My next question is for Mr. Al-Qadi. The government has released a charter impact statement which notes a number of protected rights and freedoms are potentially engaged by Bill C-70, including the freedom of expression, peaceful assembly, the right against unreasonable search and seizure, and others. So do you feel the charter rights of Canadians are adequately protected by this legislation, or there are any adjustments would you recommend? And you have also highlighted some civil liberties concern that your organization is raising with the text. So can you explain on that?
Yeah, just as I mentioned, we think firstly that this is an important bill, that the study on this bill is crucial, and we are in support of this bill to pass. However, it would need, in our opinion, a much more robust and longer study to ensure that charter rights are not violated. So, if I reiterate my points regarding the term of, a lack of definition for terms of intimidation, for example, it could cause problems down the line, undue harms that we might not be able to foresee right now because of the rush in investigating this bill. And I would reiterate the points regarding, again, peaceful protests, people exercising their democratic rights to peacefully protest that could be infringed by future governments under the pretense that they're supporting or benefiting or in association with foreign entities just because they don't like them.
Thank you. Given that protecting the integrity of the next election is important for all Canadians, so would you be supportive of this bill if it was only moving forward on Part 4?
Yes. Yeah. Well, we believe Part 4 is sufficient to ensure a fair, interference-free, and election interference-free. We believe that this bill would support the Part 4 of the bill would sufficiently support an election-free and interference-free election of 2025.
Thank you. And can you also speak to the concerns about the IRPA inadmissibility certificates?
Yes, I would pass that question actually to Nusayba.
Yeah, I think, thank you very much. This goes back to the question that was posed by MP Genius, and we would once again reiterate that there's it's very overbroad, and the application and specifically the insertion of international relations as part of the criminal code leads a lot to be asked in terms of how that's going to be, what are the implications of how that's going to impact, as earlier mentioned, people coming from dissidents coming from dictatorships, and especially given that international relations is subject to change. Somebody that may be friendly today could be hostile tomorrow, and vice versa. And so dissidents who sit on either line could change with respect to Canada's position. So being really careful of that as we're looking at how parts 1, 2, and 3 are being fleshed out. And as Ahmed noted, Part 4 is sufficient for now to be able to provide transparency where foreign interference is concerned.
Thank you, Ms. Said. C'est Monsieur Villemur encore.
Mr. Villemure, once again, please take the floor. You have 2 minutes, 2.5. Thank you so much, Chair. I have 2.5 minutes, so we will have to work quickly. I'm always curious. I mean, I've understood that your independence is substantive and is perceived to be such and is understood by you. I think this is essential for a commissioner of independence, not only to be independent, but to be seen to be independent. Now, there is a matter in the bill that's often discussed with regard to secrecy. I'm on the Ethics Committee, and often we have to deal with cabinet secrecy. Of course, I understand how that's used, and I admit that it's a necessary tool for cabinet work, but in a couple of mandates, there has been a tendency to overclassify material, to classify material at a higher level than it need be, and that's some concern to me. How do we ensure that a balance is kept? I understand that secrecy is sometimes necessary, the confidentiality is necessary, but there's that paradox. Difficult for me to respond. How could we trust a decider, the person making the decision, the decision maker, about possible ability to share material? But let me give you an example that may be an adequate response. In the requests that ministers and departments make of us, they sometimes lean on a decision made at the cabinet level. And I have no specific provision to cover that. But I think this is a difficult concept. How can I be asked to check something if I haven't all the elements in hand? All this to say that I have undertaken to discuss these matters with the intelligence agencies and all the parties, saying, look, if you want to be logical, if you want decisions that make sense, you need to provide me with all these documents. I need access to them. Meanwhile, they have gotten into the habit of providing me with summaries. So bit by bit, I'm working on that. If we go back to the 1978 was Justice Thériault's decision. I mean, it was over and done with. As soon as you said cabinet, you had no access. I see that things have changed since then, but that the Supreme Court has recently decided to support the cabinet confidence. So we're just working on it. That's the only way to move forward. So I think it was a culture of obscurity rather than a culture of transparency. And this is of ongoing concern, yes, and you're right to be worried about it.
To Mr. McGregor to bring us home. 2.5 minutes, please.
Thank you, Mr. Chair. I'd like to continue with the NCCM. Particularly with the amendments to the SOIA, like we've heard this term transnational repression come up a lot, and in particular, I was struck by the testimony that we received from members of the Tibetan community and also the Uyghur community, who both have a very troubled history with the People's Republic of China. And they were certainly listing off intimidation and all of the different tactics that have been used against members of their community because of what's going on in their home countries. I think like all of the things they want included as a part of a definition of transnational repression might be actually included already in the amendments to SOIA, but do you kind of see the conundrum that we're in, where we have different communities sort of pulling us in different ways? I do understand your concerns with the lack of a definition of intimidation. So if you wanted to add to that, please go ahead. But I also wanted to ask you, there is a theme to this bill in dealing with foreign interference, but the part that does seem to stick out are the amendments to the criminal code, updating the definition of sabotage. I asked the Minister of Justice about that, and he made reference to the fact that that provision of the criminal code sort of dates back to the 1950s, hence the necessity to update it. But You know, there are sections in the criminal code that sort of allow for, you know, proper advocacy, protest, or dissent. But do you have anything to add specifically in reference to this section on what we should be looking to for amendments?
With respect to the criminal code, I would pass it over to our legal director. However, what I would say is that we have a tremendous amount of respect for the Uyghur rights activists and the Tibet Committee for the stances that they took. And I viewed the hearings where they discussed transnational repression, and I understand the conundrum that you find yourselves in. You know, many different definitions being proposed to be amended into the legislation, but from my perspective, I would encourage that they would be included. You know, these are the folks that have really seen the front-facing, you know, real reality of foreign interference.
I'll need your colleague
but
to jump
of course,
in quickly.
but my apologies.
Yeah, happy to jump in. I just wanted to respectfully make very clear from the get-go that we're actually talking about the same community. It's not differing needs, and it's not, you know, the same communities that you're referencing would be the same communities who would also be vulnerable to many of the inadvertent issues impacting civil liberties, right, that we've raised. So it's all one and the same. And to go back to our position is that we do ultimately support. It's just about making sure that it's done in a way that protects people in Canada to be able to exercise their democratic rights and keep folks safe. And that means Uyghur activists who have been wrongly accused, for example, of connections to terrorism. And that shouldn't stop them from being able to protest in front of the China consulate, which in the past has been a suggestion of an intimidating behavior. So when we say that you're being it's kind of a conundrum. It's really not a conundrum. It's about making sure that we get it right the first time in a way that the community is safe. And with respect to the briefing that we received, the definition of intimidation was one that of like, you know, the general definition of the word. That falls far too flat to be able to protect those same communities that are the ones that you're referencing. So that's kind of, does that answer your question?
It certainly provides a lot more guidance, so thank you.
Thank you, Mr. McGregor. So I'd like to thank the witnesses for being here today and joining us on such short notice. Your contributions are most helpful. They will help us moving forward in our study. And you may withdraw at this point if you wish to do so. I would like to remind the committee that amendments to Bill C-70 must be submitted to the clerk by 4 p.m. Eastern Standard Time tomorrow. It is important for members to note that pursuant to the order adopted by the House on May 30th, the 4 p.m. deadline to submit amendments is firm. This means that any amendments submitted to the clerk after the deadline and any amendments moved from the floor during clause-by-clause consideration of the bill will not be considered by the committee. The clerk has advised me that the amendments package, when it's distributed, if there are fewer than 20 amendments, we will probably get that by probably 6 o'clock Friday. If there are more than that, it's an open question when we'll get it. I would also remind the committee that we'll meet again on Monday at 3:30, and we will sit here until we're done. And that will depend on the amendments. There you go. I'd also like to thank all of the committee personnel who have stuck with us through all of this, in particular the ongoing endurance of our analysts who have been here hour upon hour upon hour, and also the perseverance of our clerk. You know, a week ago we dumped on his lap a massive list, and he made breakfast. A massive number of witnesses. He's had to communicate and figure out who's available and when and adjust and negotiate. And so I want to thank everyone involved. So thank you. And having said that, let's adjourn. Good to be here.